appeal in the matter of the Queen on the application of Aviva Insurance Limited and another, and the Secretary of State for Work and Pensions, partner.
My Lord, morning. If I may, I'll deal briefly with three catch-up points.
Yeah.
First, Mr. Bainbridge's circumstances post-payment by Swiss Re. Mr. Bainbridge sadly died on the 28th of October 2020. From the settlement of his claim on the 10th of April 2019 to his death 16 months later, he received £14,768 by way of IIDB and £7,232 by way of attendance allowance.
Sorry, the last figure?
£7,232. In addition to the other benefits to which he was entitled. Secondly, in respect of NHS charges, NHS charges are addressed by the Health and Social Care Community Health and Standards Act 2003.
Sorry, say that again. Health and
Yes, Health and Social Care, brackets, Community Health and Standards, close brackets, Act 2003. As my Lord Justice Dingemans said, there's been a system of recovery under the Road Traffic Act 1988 and a different system applicable to incidents after the 29th of January 2007. There is technical guidance published by the government, and having looked at that, we doubt that we can improve on that by way of a note to the court. And what we would suggest, subject to the court's views, is that we send the link to that to the court, as opposed to trying to consolidate it in any way. I anticipate that the insurers will want to say something about all of that, namely to the effect that there are provisions for contributory negligence and things like that. So they will make a point that it's not beyond the wit of Parliament to do this in a different way. But
that was apparent from the document we looked at yesterday.
Yes, indeed. And the court has my submission that that's...
You say that doesn't
that doesn't really matter. Third point, my Lord Justice Dingemans asked about section 22(4 and whether we could discern from the material what the purpose of that was. And that is in fact referred to in paragraph 50 of Mr. Justice Henshaw's judgment in this case, when he records a statement made by the promoting minister in relation to what section 22(4 was directed at in his mind. And what's recorded in the judgment is that it permits a restriction if there's an upper limit in the insurance.
So which paragraph of the judgment?
So it's paragraph 50 of the judgment. Is it? So doing the best that one can with that, what seems to be envisaged as a possibility is that if there's an upper limit in the liability insurance policy, it might be appropriate to reduce the amount of contribution made by the insurer to the state. But in circumstances where compulsory EL cover is fixed at £10 million per claim, it's not immediately obvious why it would be necessary for some sort of reduction to the insurer's liability in respect of far more modest state benefits, even in the circumstances of a catastrophic case. So it rather looks like the state's keeping its options open for the future in terms of reducing the insurer's liability to the state if there's some good reason having regard to the market, but none has been identified so far.
Well, overseas insurance policies can be very different limits.
My Lord. My Lord, on the Welsh Bill case, and I propose just to make 3 points, and the court's had submissions from us already. And then I'll deal with my final point on ground 1 and then move on to everything else. So the first point I make in respect of the Welsh Bill judgment and the obiter judgment of Lord Mance is that obviously we're not appealing against that judgment. So we do not need to apply the same level of scrutiny and criticism to that as we do to the judge's judgment in this case. And it largely suffices for me to say that the errors made in respect of MWRF and fair balance in the Welsh Bill case, we say, are similar errors that have been made by the judge in this case. The judge's judgment in this case largely tracks Lord Mance, and we say therefore they are effectively both wrong in terms of the approach to MWRF and fair balance for similar but not identical reasons. And we note, of course, that the Supreme Court in the Welsh Bill case was sitting as a first instance court by reason of the nature of the reference.
Well, yeah, I wondered about that. Without getting too far into the doctrine of precedent, the fact of the matter is it's all overture anyway.
Yes.
Because they decided it was effectively ultra vires.
Yes.
And also, you say, well, the law has moved on since the Welsh Bill case, in the sense that there are now authorities, including SC, and trouble with everything being initials,
Yes,
DA,
DA.
Lord Wilson, I think
Yes.
it is, isn't it? Together with various decisions in this court, which make it quite clear that the test, whatever it is, manifestly without reasonable foundation, with all the variations to it that Lord Reid talks about, is applicable to all four
Yes.
of the conditions.
Yes, my lord.
Consider it.
And not only that, it could never be ratio in terms of this act, because this is a different act,
No, quite.
and it has to be put in its own context.
Yeah.
And that is my second point. The second point, it is a key responsibility, of course, for the judge to contextualise himself. And the process of contextualisation that Lord Mance carried out in the Welsh Bill case was necessarily different from that which the judge here was required to carry out. So I note that Lord Mance had already decided, before considering A1P1, that the Welsh Assembly was not competent to determine this issue. So his conclusions on ground one inevitably provided some context for how he approached the bill in terms of fair balance.
Yeah.
What is also apparent from paragraph 57 of the judgment is that part of the reasoning of Lord Mance is that he was concerned and troubled by the way in which the bill would alter the law of tort and contract, which he did not consider that the Welsh Assembly should do, for the reasons set out in paragraph 57 and 58, having regard to English law, choice of law in contracts. None of that applies to decisions of the United Kingdom Parliament. And we say that having carried out the correct and necessary process of contextualisation, that probably explains Lord Mance's conclusion, which he reaches at paragraph 63A, that the legislation or draft legislation that he had before him was not social remedial legislation. But we say that the process of judicial orientation results in a different outcome when applied to the 1997 Act in this context, because of the nature of the material which the court had before it, and staying within the realm of what Lord Reid has said is permissible. We say it is not possible to read and consider the passionate and informed debates in Parliament and the detailed and painstaking work of the Select Committee, taking evidence from the TUC and Insurers, and the Royal Commissions before them, and not conclude that we are operating within the realm of high social policy, and that is a very material factor when it comes to fair balance. That was important context, as was the fact that, for want of a better expression, battles over court-made tort law and its impact upon workers and the interests of trade unions have been a defining feature of the social history of the 20th century. And it was necessary for the court to appreciate that what it had before it as relevant and important context was that history and how that informed the settlement that is ultimately reached in 1997. So insofar as the judge here, as he has done, has concluded that he did not have social remedial legislation before him, in the same way that Lord Mance reached that conclusion, we respectfully say that he was wrong to do so.
And it is a striking consequence of what the insurers argue for, that if they're right, the tortfeasor remains responsible for everything.
Well, that is a consequence, yes.
Which would be in one sense, quite surprising.
Yes, they say they're not concerned with tortfeasors. The tortfeasors can look after themselves in the same way that the insurers here are looking after themselves. But that is an inevitable consequence of what they have achieved in this litigation, which plainly upsets the balance that has been reached in 1997. The third point that I make, my final point on Welsh Bill, is that the striking conclusions that have been reached at paragraph 57 in that judgment by Lord Mance about the issues that arise in the context of insurance contracts, we say, with the greatest of respect, are somewhat out on a limb and therefore contravene the other principle. Because what Lord Mance is saying in paragraph 57, in substance, is that once an insurance contract has been concluded, it can never be the subject of interference, because an insurer would never legitimately have expected that when pricing the risk. Here, the context is the convention, and the convention, of course, has certain non-derogable rights, but the rights created by private law contracts are not amongst them. So the principle of inviolability of insurance contracts by reference to the interests of insurers is one that we say is stated too widely to be acceptable.
Can you just help on who agreed with Lord Mance on his, what you say is overture?
Yes, I think in fairness, on that point, they all agreed, but without any particular additional reasoning.
They all agreed with it. What, Lord Thomas and Baroness Hill as well?
Let me remind myself.
Well, Lord Thomas puts it very much in terms of the effect of the proposed section 14 of the bill going beyond what was permissible in terms of legislative competence, section 108. That's paragraph 133 of his judgment.
Yes.
So I think he's. In a sense, his conclusion is bound up with the point about whether or not it was the legislature was competent.
Yeah, so, no, sorry, I have misspoken. So looking then at, what was it, 128. Yeah, so no violation. To that extent, yes. So there's agreement on the separate jurisdictional aspect and difference, respectful difference there. Well, forgive me. Yeah, so 133, as my lord says, is directed to a different point. That's no, he does say that there is the limited interference at 133, and if one need with the conclusion then at 139.
And in fact, I mean, on one view, Lord Thomas expresses a different view to that of Lord Mance, because if you look at 137,
Yes.
Page 1508 of the bundle, what he says there is that he doesn't think that there could be a legitimate expectation on the part of insurers that the state would not be entitled to change its policy for charging and drawing benefit enjoyed by wrongdoers.
Yes, so perhaps I can put it out in this way, by reference to how I put my second point. Lord Thomas contextualises it quite differently from Lord Mance, because it's very much within the framework of the Government of Wales Act. But ultimately, at least in part, he does get to the same conclusion that there is some interference with A1B1.
Well, and unlawful interference.
Yeah, unlawful interference, yes.
Yeah.
that's what I'm proposing to say there on Welsh Bill, recognising, of course, the value of the contribution of the judges, but for the reasons given, we say it shouldn't have been treated as determinative or even persuasive in the present case.
And I have your point about David. What do you say about whether this is binding on us? You said it was first instance. As a matter of precedence, is this binding on us?
There's nothing that binds. There's no law that binds the court in that judgment that's relevant to this case. So it is not a source of law, and therefore it's not binding.
But the Supreme Court, if this was on the 97 Act, would that be binding on us, even though they were sitting at first instance in a devolution matter? Anyway,
My lord,
sorry to ask a difficult
No.
question, but
perfectly.
it's just helpful to have absolute chapter and verse on
Yes.
the status. Thank you.
It's a reference under section 112 of the Government of Wales Act,
Yes.
2006, and it's presumably a similar provision in the Scottish legislation, and it comes to the Supreme Court as it is the
Directly.
Supreme Court of the United Kingdom.
Well, in fact, it goes, is it the Supreme Court or the Privy Council?
It's
No,
the
it is the
Supreme
Supreme
Court.
Court. It's a statutory reference to the Supreme
It's the
Court.
Supreme Court. It's
We
not
know the
Privy
Supreme
Council.
Court has looked at this very recently in the context of Scottish legislation, so there may well be relevant jurisprudence there. So I won't answer that on my feet.
Thank you very much.
Short point, and a final point, but an important point then on ground one, the JCWI and Christian Institute. So the issue about what one does when the legislation is not incompatible in virtually every case. Now, note please what is said in the supplemental judgment of paragraphs 29 and 30.
Sorry, which reference is, which authority is this?
Sorry, in our case, in Aviva, supplemental judgment, paragraphs 29 and 30.
Thank you.
The court records the fact that the challenges and the conclusions are of general application and not limited to specific insurers. And I recall then that no case was led by these insurers that the particular burden complained of was limited to them. So this is not and was not a challenge similar to a social security or an immigration challenge, which arises under secondary legislation with delegated decision-making power, which responds to the facts of an individual case. This was very much a face-on challenge to the balance struck in the primary legislation. And in that regard, it's necessary to consider JCWI behind tab 53.
Yeah.
So bonds. One can take from the head note before looking at the judgment that, as here, was a challenge to the validity of a scheme in primary legislation by reference to convention rights. And the appeal was allowed on the basis that the scheme would not violate convention rights in all or nearly all cases. And the reasons are set out at paragraph 117 of Lord Justice Hickenbottom's judgment.
Sorry, is that the right, 117?
116, so starting at 116 at page 2157 of the authorities bundle. So the claim was not brought by any individual claiming that he or she has been the victim of a discrimination as a result of the operation of the scheme. Rather, it's a challenge to the validity of the statutory provisions themselves. So in the context of our case, this isn't an individual challenge. This is a challenge to the statutory provisions. So 117, in respect to the former, as Baroness Hale, Lord Reed and Lord Hodge, with whom Lord Wilson and Lord Hughes agreed, put it in Christian Institute and Lord Advocate. The court has explained that an ab ante challenge to the validity of legislation on the basis of a lack of proportionality faces a high hurdle. The legislative provision is capable of being operated in a manner which is compatible with convention rights, in that it will not give rise to an unjustified interference with Article 8 rights in all or almost all cases, legislation itself will not be incompatible with convention rights. See, BB.
That's because it might be operated in a way that is compatible with the relevant rights.
Yes.
Here, what is said are the 3 objectionable features which feature in every single case. So it's not one of those cases.
They don't, because they don't apply to prospective insurance contracts. So the insurers say that the scheme is objectionable only to a certain subset of contracts.
Yeah. But objectionable to all of that, all of those.
Yes.
It can't be operated. I mean, the whole point about the Christian Institute case is that the Act might have been capable of acting fairly, and therefore you're never going to succeed in a challenge before it comes into force. Here, the Act is in force.
In relation to legacy insurance contracts, it will always operate in a particular way.
Yes, but in respect of the same Act, though, covers the whole field. It's all insurance contracts.
I'm not sure that's necessarily a valid ground of distinction, is it?
Well,
Does
why?
it have to be capable of being operated in a convention-compliant way in any given case?
No. If it's a challenge to the balance struck in the primary legislation, if it has to be demonstrated to the very high hurdle that it's incapable of challenge, incapable of
Yes,
being.
the judge has held
Yes.
that because of these 3 features, it is always incompatible. You're quite able to say the judge was wrong about that. We
Yes.
understand that point. But this adds nothing to the argument.
Well, respectfully, the reason I disagree is because in circumstances where the insurers concede and accept the legislation operates compatibly to all of their contracts which postdate the Act coming into force, then they are accepting that it can be operated in a way that doesn't interfere
But
with
the
their
way
rights.
it's put in the way it's put in the Christian Institute case is it is capable of being operated in a manner which is compatible with convention rights. In that, it will not give rise to an unjustified interference with Article 8 rights in all or almost all cases.
Yes.
And the point that my Lord's putting to you is that in relation to contracts entered into after 1997, that's one thing, but in relation to all contracts before 1997, it operates in the way of which the insurers complain.
I recognise that, and I won't test the court's patience, but in circumstances where the Act makes no difference between contracts before and after, then it is not open for the insurers to say that in respect of this species of right, there's an unjustifiable interference, but in respect of this other species, i.e. the new contracts, there is no unjustifiable interference when it all originates from the same statutory scheme. That's my submission.
So for that submission, we ignore the subsetting aspect. We treat it all as a whole.
Yes. All as a whole, in what respect, my lady?
Well, both before, pre and post March 1997
Yes.
cases, contracts.
Yes, because the primary legislation does not recognise
Yeah.
any such distinction.
Yeah.
It's a short point. The court has my fundamental points in terms of ground 1, but it is an important point. And I propose then to move to ground 2. To some extent, I'll take grounds 2 and 3 in tandem, but without dividing them. They're different points, of course. Limitation and justiciability. Dealing first with the answer for the position on limitation as queried by my Lord Justice Dingemans yesterday, if I can ask the court please to look at paragraphs 50 and 51 of the supplemental judgment.
50 and 51.
Yes, my Lord.
Thank you.
So what the parties had proposed and the court agreed to do was to stand over the following remedy-related questions. 1, whether damages are in fact necessary to afford just satisfaction under Section 83 of the HRA. 2, what sort of claim arises in principle. The claimants suggest Kleinwood, Benson or Woolwich. We disagree. We have all sorts of points which the insurers will no doubt look to meet in due course. And 3, limitation under the HRA, or if applicable under the Limitation Act 1980. Then there's an issue which is not relevant about whether they're proper to the Administrative Court or the Chancery Division. But the point is, the party's position, as a matter of the proportionate case management of this litigation is that that is how we are proceeding in terms of limitation. And so we say all of that is properly stood over in the way that has been recorded in paragraph 51. In terms of...
Did any judge sign off on this agreement between the parties before it was presented to Mr. Justice Central?
Any other judge?
Yes. When was this ever case managed in the administrative court?
No.
Where remedy was? Because just so that you can deal fairly with it, and I'll obviously ask Mr. Kent, it creates absolute chaos if you hive off issues of remedy when the court's got no real idea of how a claim is being put.
Well, my lord, my point was this is far too premature, and that any matter of consequential hearings before a Chancery division should really be treated as some sort of inquiry by a master, which one gets to at a very late stage in the litigation, and that was my submission before the judge. I said,
yes, but at least a judge should have required, if able to manage this, should have required an outline of the case of how they put their claim in damages, your response to it in terms of limitation, and then one would have had a fair idea of what was going on, rather than, well, this might be Klein Wolf Benson, this might be limitation, this might be statute barred.
well, my lord, I entirely agree.
Good. Okay, well, all I'm doing is giving you a fair opportunity to comment in case anything's said about it in a judgment.
Well, my lord, thank you. And what I say then is, of course, I note all of that. We had 2 days before the judge to deal with a lot of heavy issues. It was obvious, and still is obvious to me, that the sorts of claims that have been intimated in paragraph 50 give rise to very substantial further issues of principle, not just a quantum calculation exercise. And that's what I said to the judge. This needs to come back. There's nothing wrong with it being bifurcated in the administrative court. That might be sensible. And that was my position, but I failed to persuade the judge on that. So that's all I really wish to say.
Thank you.
So you were in favour of it remaining in the administrative court?
Absolutely. Yes.
It's certainly not an appropriate series of issues for it's not like a sort of an account
No.
in the Chancery division. So at the moment I'm slightly puzzled by the judge's conclusion it should go to the Chancery division, but there we are. No doubt one or other of my judges will be very pleased to try us in due course.
My lord, on points then, we say that the balance struck by Section 6 and Section 22 and the framework of the 1997 Act were matters which were known about upon the commencement of the Act in October 1997. Putting this case and this challenge in context then, we say that from the 6th of October 1997, insurers and their policies had to respond to Section 6 liabilities in the future. And this isn't properly described as a continuing act when considered in the context of the insurance market, because as of that date, they know what the liabilities are which have been imposed upon them. They don't know the quantum of them, but that's a matter for them. They will forecast, invest and reinsure in order to accommodate all of that. But insofar as there is an interference in human rights, we say that that is the manifestation of the liability which the state creates on the 6th of October 1997.
So this is your limitation point.
Well, it's perhaps being too ambitious to do justiciability and limitation at the same time. But my first point is, if the liability is created or the interference occurs on the 6th of October 1997, human rights had not been brought home. And therefore, the challenge properly understood is non-justiciable.
The difficulty you've got with this argument is the terms of Section 22, subsection 1, which says if a compensation payment is made,
Yes.
then the policy is treated as covering. So the as it were, the deeming provision under
Yes.
the statute is only actually incorporated into the policy when the compensation payment is made.
But
So it doesn't say, as it could have done, every contract of insurance shall, or every policy of insurance shall be deemed to contain this provision. then your argument would be much more straightforward when I follow that. But it does seem to me section 22(1) suggests the contrary argument may be correct.
Well, I would say respectfully, in the context of a human rights challenge and looking at the practical effect of this, we say that the proper description is in fact the one that the insurers put in their statement of facts and grounds at paragraph 5, namely the complaint is the creation of a deeming insurance clause by section 22(1). So the insertion into policies, and bearing in mind we're only now concerned with existing policies.
Can we just look at that? Sorry, that's paragraph 5 of the
Statement of facts and grounds.
statement of facts.
That's which tab of the core bundle?
So that's tab 28, is it?
Paragraph 5.
One sees how it's put in 433 on paragraph 5 of 433. They say, but for the deeming provision in section 22 of 1997 Act, insurers who issued such policies or their successors would not
Sorry, which
rely.
paragraph are you reading from?
Facts. It's page 433, my lord, of the core
Yes.
bundle.
Yeah,
Paragraph 5 at the bottom of the page. That might, and in fact probably isn't, a response to my lord the Chancellor's point to me, because that's capable of being read in both ways. But my submission is that in practical terms, the complaint is very much to the effect that as of that date, they have contracts and the state has interfered with them by telling the insurers that they're going to have to respond in the future whenever they make a payment of damages to an additional statutory liability. And part of the justification argument is that is precisely what legislation does. You're going to have to mitigate that for yourselves, forecast, reinsure, do what you can. So that's the first point. The second point is on section 22(4) itself. Insofar as that's the target, then we say, well, they've known about the power in section 22(4) for some time. It's connected to the section 22(1) argument, but insofar as they're saying that the Secretary of State was obliged to cut down the section 22(1) liability by making regulations under section 22(4), then she should have done so at the outset, because that's the nature of the complaint.
So this is going to justiciability or limitation?
This is still going to justiciability, my lord.
Why is it?
Because
Well, in the first instance, but then it goes to limitation 2, because one then considers the effect of section 7 of the Human Rights Act.
But if it's justiciable
Yes.
when it comes into force,
Yes,
it's still justiciable now, it's just it may be too late to complain about it.
correct. So if I'm
So why is it justiciable if you're accepting that the Secretary of State on this analysis should have made the regulations earlier?
these all predate the Human Rights Act.
Well, I'm not. So I'm saying that she was under no such obligation in 97.
As I understood your point here, it was that the relevant interference, your point about section 22(1) is that the relevant interference occurred when the statute came into force in October 1997.
Yes.
That antedated the coming into force of the Human Rights Act, and therefore it's not justiciable.
Yes. First point. Yes.
So far as 22(4) is concerned, you're saying the same thing, are you? That insofar as the insurers are saying the Secretary of State should have regulated, that regulation should have occurred from the outset, from October 1997.
Yes. In substance, it's the same point.
But can I just ask this? There have been acts which predated the Human Rights Act, which after the event have, with the Human Rights Act, been put right.
Absolutely.
So why does this make it justiciable?
Because it depends on the nature of the complaint in question. I entirely accept that there will be law on the statute book, which is historic, which applied today is capable of violating human rights.
Depends on when the interference is.
Yes, it depends on when the interference is properly understood.
So are you looking or focusing on the way the complaint is put? You're relying on the way the complaint is put,
Yes.
but we have to look at substance, not form, don't we?
But Well, my submission is based on the substance.
Yeah.
The substance of the complaint is, we've got a book of policies here in October 1997. You are now telling us we have to respond to all sorts of long-tail liabilities that are going to emerge in the future because we're holding this book.
Just assume they're right
Yes.
in their analysis of Article 1, Protocol 1. They realise that in October 97, but they can't do anything until the Human Rights Act comes into force. So why does that make it non-justiciable? Maybe you could say they should have bought it when the Human Rights Act came into force. I understand that and all the limitation points.
Yes.
Subject to the fact the judge seems to have hived it off, but not hived off this bit of it. But that is different from saying it's not justiciable.
That is different, but one still has to identify as a matter of substance, not form, what the actual interference is. And if that interference was carried out by the state in 1997, it is non-justiciable. And the fact that there might be some...
And this is continuing interference.
Well, yes.
And then you've got the trigger at 22.1. I mean, how can you say, yes, you should have complained, you have no right to complain, apart from going to Europe, until 2000. You didn't complain then, but in fact your loss has then accrued in 2019 with Mr. Bainbridge.
But that's a manifestation of a risk under a policy, because that's the nature of insurance, is that they know in 1997 that they've got a policy responsive to Mr. Bainbridge, so they know that if he develops the injury or disease, they've got to respond to that at some point in the future. But all of those matters are known to them then. All that happens in 2019 is that the risk in fact materialises. That's the nature of insurance. So it is important to consider the proper context. And the fact that there are other examples in which the true interference happens later, but dates back to statutes.
The whole case on interference is that it's as a consequence of what has happened after 1997 that the statute is non-compliant with A1P1.
Well, query then, because the order
Yeah,
records...
but then you go back to the debate about the dates in the order.
Yes. So the dates in the order...
Well,
Put those to one side, because
Right.
they came after the event.
But I mean, the reality is that what's being said is, look, because of Fairchild and the subsequent cases and the Compensation Act 2006, we are now left with this liability which goes way beyond anything that was contemplated.
I will take that, because if the true complaint is, it's the claim form date, which is what I would have analysed this as being the date in which the complaint is said to arise, then that's fine. So they say the interference arises on the date of the claim form and not before, and my arguments on justiciability disappear. I accept that. But that isn't where we've ended up.
I see. So is your justiciability argument predicated on the date point, the date in the order point?
It's informed by that. Is it predicated on that? No, because the arguments are slightly amorphous on the other side, no disrespect intended, but if it's what the paragraph 5 statement of fact and grounds argument, we are complaining about the interference with our contracts in 1997, which is how Lord Mance would have it, and we say it's non-justiciable. If it's something else, and of course my arguments respond to what it is. But if they're saying, no, it's the date of the claim form, fine, that has a material bearing, obviously, in terms of any financial claims, leaving all of that to one side. If it's the date of the claim form, it's justiciable for the reasons given by my Lord Justice Dingemans, that what one then has is a historic statute which has created a human rights interference some 25 years later, and that is not objectionable in terms of values and competence.
So your answer to my Lord the Chancellor's point on section 22.1 is that is just a manifestation of the interference which itself originated upon the implementation of the Act.
Yes.
And there are, of course, in a completely different context, private law context, lots of cases about insurers and contingent damage and when damage occurs with bundles of rights and all the rest of it.
Yes.
Now, I don't think anybody's suggesting that any of those cases are of any relevance. Is that right? So Sefton, AXA, all those cases?
Well, I'm not.
No.
All right.
So the court, I hope, has my point, and I don't need to emphasise the importance of limitation in public law proceedings. This is really the limitation point. If this really was a complaint about something that happened much earlier, then of course it must have been brought.
How does that feature now with the apparent agreement of the parties that limitation is kicked off to these other proceedings?
I'm going to argue limitation, as and when I'm entitled to do so.
But you're arguing limitation now as well.
Yes, I'm going to try and have my cake.
Just so you can deal with it fairly, I mean, that shows that this should have been managed beforehand anyway. You agreed what you agreed. Do we have any evidence of what you agreed? Because it strikes me as potentially abusive to argue a limitation in front of us and limitation in a different context. You can't do it twice.
I'm not, and I'm making it absolutely clear what I'm arguing now and what I'm reserving. I'm reserving limitation arguments responsive to particular causes of action which have not yet been formulated. In no sense is that abusive.
Well, I would agree with that if they haven't yet been formulated. But that, we don't know what has been formulated and what hasn't, because you've come to an agreement that we haven't seen. What is the agreement that you made about damages and how all this was to be dealt with? Was it reduced to writing?
My Lord, I recognise and accept and do not in any sense push back on that. All we have is what is recorded, for better or for worse, in paragraphs 50 to 54.
On the face of it, if the judge, leaving limitation issues to one side, the effect of that last paragraph of the declaration on page 253 of the bundle is that the insurers can trawl back to October 2000 and claw back hundreds of millions of pounds.
Of course it is.
Which is just quite extraordinary that should be, as it were, part of a declaration without anybody having said, well, hang on a moment, this is all very interesting, but there are all sorts of limitation issues.
Well, I did. I said that. That was the...
But nothing's recorded in the court's order. I mean, there's nothing in the court order that says that limitation is reserved to a subsequent date. I mean, I suppose you could say it's in the judgment, but it's not in the order.
Yes. I certainly have the court's point, but I maintain that I knew all that and said all of that to the judge, and that was in recognition of the critical importance to everybody of the significance of all of those points. But at the same time, we've got to do the best we can with the time allocated to us by the court and use an appropriate amount of the court's resources.
Look at paragraph 92 of the main judgment, don't we?
Yeah.
Because this sets out in detail,
Page 2 of the main.
page 180, which addresses this point head on.
No, 92.
Yes.
Well, yes,
Just from my point at least, I just need to reread it.
Of course.
But it seems to me to.
Yeah, okay, and that's where the judge, you're quite right, that's where the judge says it's better if questions of limitation are
So
reserved.
quite how we marry that into the declaration, I don't
Well, that's a
know.
different
But this
issue.
is
It's
dealing
part
with the
of
point.
he picks it up in the supplementary judgment as well.
but insofar as it records my agreement that it would be appropriate, I wasn't agreeing that it would be appropriate to do it in the way that's set out in the consequentials judgment. I was agreeing that if we're only at a stage of an account before the master, that's fine, then we transfer. What I argued and what I lost on at the consequential stage is whether we were anywhere near that stage. And I said, no, we need to come back before the administrative court, as is recorded in paragraph 50, and have more argument on what these claims really are. And I lost.
Well,
There was a section 31(2)(a) point.
Yes.
It said as well.
But it is difficult to understand how, in the light of this, we're looking at limitation at all at this stage, and that it forms the basis of one of your grounds of challenge. I think that's what
Yeah.
that's what we're trying to grapple with.
I can understand the judge's thinking that until, as it were, everything was, the issues of principle were clear, issues of limitation were all for the future.
Yes, if having regard to the point very fairly put to me that there is a risk that I am trying to overstep in terms of running it as a limitation argument here when I've very clearly reserved it, then I will take my reservation, because that is a critical and important matter, and I'll pursue it before this court on the basis of justiciability only, frankly, because I'm not looking to do something which is in any sense abusive. So it's certainly not the
Well,
intent.
speaking for myself, I would be uncomfortable in dealing with limitation issues before this court.
My lord.
All that does indicate, though, is that this should have been case managed, and the parties should not have entered into an agreement where the claims could have been parked until they were actually known about, because the judge didn't then fairly know what was going to happen.
Well, my lord, I did not enter into that agreement. The extent of my agreement was, if we ever get to a stage when all we're doing is Scott schedules, then fine. But I had no agreement, and there is no agreement which said anything other than that. And that's the point I made to the judge and lost on. So it would not be fair to criticise my client for that, because that's not the agreement at all.
Right. It might be sensible, given the time, to move on.
Yes, I can take the other points quickly. Ground 4, victim status, substantial interest. So the point here effectively being the standing point by reference to Section 7, Human Rights Act, or general principles. And we say that one has to look at both insurers individually. Human rights are individual rights. One has to look at the impact upon them individually. Aviva has no financial liability in respect of the Bainbridge certificate because it was discharged by Swiss Re. So it's not paid, and therefore there has been no interference with its rights.
But in the unlikely eventuality, and it may indeed be about as unlikely as anything could ever be, that the Swiss Reinsurance Company went into liquidation, then Aviva would be primarily liable for everything, wouldn't they?
Absolutely so.
So that's a contingent liability they're under,
Yes.
as any reinsured is under. Reinsurance protects them against the risk which they've insured. It doesn't give them a cast iron guarantee that they won't be liable to their own insured.
No, but Dudgeon tells us from Strasbourg that one doesn't approach this by reference to hypothetical and improbable.
It's not hypothetical.
It is.
The primary liability remains with the insurer.
As a matter of contract law, of
As a
course.
matter of law.
Yes, I accept that, but we are in a different part of the law now.
Right.
We're looking at human rights, personal rights. Is there anything other than a very theoretical possibility that Swiss Re can't meet the liabilities under the Bainbridge certificate? Answer, no. They have not suggested that. They would need to lead evidence to that effect. So, my lord, I accept the point as it stands as a matter of insurance law, but one has to have a slightly different approach towards this.
Okay.
So Aviva's interest in the claim, and indeed all others, leaving aside the coverage outside the United Kingdom, which came in at a very late stage, but leaving aside all of that, their interest in all of the affected claims ended in 2015 by reason of the reinsurance of their back book by Swiss Re.
Yeah. Swiss Re isn't a victim because it went into it with its eyes open.
My lord. All one then has is a point about the premium, and the judge says, well, Aviva's premium was probably increased. Query, where's the evidence for that? If this truly is some sort of Woolwich/Littlewoods type claim, the evidence about that sort of economic impact on the market would need to have very considerable and weighty
The reinsurance contract was disclosed, but with the premium provisions redacted.
Yes, well, they
How
thought.
could the judge possibly reach that conclusion?
Well, my lord,
Nobody knows. I mean, they've chosen not to produce the evidence.
we don't know what the premium is as a matter of the number, but we don't know how they actually negotiated it. Theoretically, it could have been negotiated on
What
the.
we don't know is whether or not the premium was negotiated on the basis that there were these liabilities.
No, exactly. The Swiss Re said, we've got some pretty good legal advice that we'll go along to the court and we'll sweep all these liabilities away. So the premium will calculate on the basis that there are no liabilities. We just don't know.
Took the risk.
Yeah.
Okay. So that's ground 4.
Yeah. And my Lord, ground 5, then the approach under 22(4) of the Act and how that interacts with section 6. So is there advisories to compel the Secretary of State under section 22(4) to do what they say is necessary? And the first point is by reference to section 6, which is behind tab 7. See section 6.1 and 6.3, excluding the Act from either House of Parliament for proceedings in connection with.
Sorry, looking at section 6.
Section 6, please, of 153. So the general principle 6.1 familiar, it is unlawful for a public authority to act in a way which is incompatible with the Convention right. 6.3, in this section, public authority includes a court of any person carrying functions of a public nature, but does not include either House of Parliament or a person exercising functions in connection with proceedings in Parliament. And we say that that excludes an order as made in this order, compelling the Secretary of State to bring forward the regulations in terms of a complete and honest confession. It is right that we presented this argument primarily by reference to section 6.6 below. So a similar and related provision, which is also preserving the constitutional balance of the Human Rights Act, which on one interpretation is directly on point because we're talking about laying regulations. But there is an authority which we acknowledge, which is the judgment of the Supreme Court in T, which suggests that this sort of negative regulation might not be caught by section 6.6. And having considered that carefully, our position is that we would have to reserve that for the Supreme Court in terms of section 6.6, but in any event, section 6.3 is to the same effect.
Why?
Well, because making a regulation is exercising a function in connection with proceedings in Parliament, so it's not unlawful not to do that.
So what is the gist of your submission then?
That part of the order could not properly have been made insofar as it was concluding that there was unlawful act on the part of my client in not exercising her power under section 22(4).
Because of section 6.3?
Yes.
Because to exercise the power under the power to make regulations, your client will be exercising functions of connection with proceedings in Parliament.
Yes.
Well, if you're making a regulation, you make it outside, it's then approved by Parliament or not, but the power is beforehand.
The regulation.
Yeah, I mean, the Secretary of State signs the regulations that are drafted on his or her behalf, and then they'll be signed, and then Parliament will approve them or not, but the actual exercise of the function is not in connection with proceedings in Parliament. It's pursuant to statutory. Has this argument ever been advanced before in the 20-odd years we've had this Act?
In relation to regulations?
I've not seen it and obviously researched it, but we've not alighted on it properly being the subject of determination.
I have to say, it seems to me a surprising
Yes, well,
submission. And the Secretary of State full knowledge that you're advancing it?
well, my Lord, in light of the points that the
It has
Court
all
is
sorts
making
of
to me,
implications, doesn't it?
You know, this
Yes.
would potentially drive a cart and horses through some of the reliefs and remedies available on the Human Rights Act. If the government wants to make that submission, that's fine. I just want to make sure that this is on a fully advised basis rather than a clever thought and analysis.
my Lord, can I then take that and consider it?
Yes. Let's move
Thank you.
on.
Start dates I've dealt with, so I don't think I need to say anything more.
No.
And I've also dealt with Article 9. The only other point is reading down whether this legislation, this primary legislation, could be read down. So this is paragraph 18 of the supplemental judgment. Yes, so it's the well-understood argument by reference to Gade and Mendoza. You read down as long as it's not against the grain. And my submission, having regard to the findings as we interpreted them in the judgment, is that the right course, by reference to cases such as Matheson in the Supreme Court, would be to make a declaration simpliciter and allow then proper consideration of the unlawfulness that's been identified and revealed by the judgment, because it's going to require careful thought. The judge preferred the arguments of the insurer that he could and should read down because to do so would not be against the grain of the legislation. But the error effectively repeats the submissions I've already made in respect of ground 1, is that the grain of the legislation that the judge understood to be revealed by the legislation was not in fact the true intention of the legislation, because it's perfectly clear what the face of the statute says, and it doesn't allow for this. The reason why the judge was comforted that he could read down was by reference to what I've described previously as the lawmaker's own other intention. And he said that because the Act is really designed to further those objectives, then insofar as it doesn't, one can simply read it down. When the judge says read down, what he in fact does, we say, is actually rewrite the whole scheme. One
It's
looks,
purely parasitic, this ground, isn't it?
it's parasitic in the sense that it's the same error feeds into it. So the same error in ground 1 about,
If you were wrong about ground 1,
yes,
then your real complaint would be no more than that the judge, the declaration he made had gone further than it should have done. And he
yes.
should have made, as it were, a declaration simplicity. I'm not sure where it gets you, frankly, in terms of practical reality, if I put it that way. I mean, this seems to me to be, and I think my lady's putting it as a polite way of putting it, it's an academic point if you're wrong about ground 1.
I'm not necessarily sure. I know at the risk of going back to things like remedy and the nature of the illegality, it might be significant. Because if this is in truth a Woolwich claim, which depends on whether the defendant has acted unlawfully, then a finding that she's acted unlawfully as opposed to a declaration in respect of the proper interpretation of the statute may well have different consequences. So it may well not be purely academic for that reason, but that in a sense reinforces the criticism properly made by Lord Justice Dingemans about the difficulty in trying to hide that off. Because if there's a very substantial connection between the nature of the unlawful act and the sort of remedy that follows from it, then that's a matter which should properly be considered at the stage of the order, and that is a point I made. This is a problem when one has shadows of tax law and consequences that might follow from unlawfully levied sums there being brought in.
What you're really saying, is this right, is that the judge should simply have made a declaration and then left it to Parliament to sort out.
Yes, that is the usual remedy in the Supreme Court grants, and indeed lower courts, following a case of this nature for good reason.
Well, it's Matheson, isn't it?
Yeah, it's Matheson. Absolutely so, and that's what I put before the judge and said that's the right approach here, because you're then bringing yourself into the territory of legislative choices, because Parliament, we say, may still not be of the view that the matching scheme is appropriate or necessary for good reason, or even if it agrees that that's the logic of the judgment and nothing can be done, it might start to do something completely different. going forward, and that's a matter for Parliament. So it is a question in terms of constitutional balance and the significance and importance that declarations can have.
Perhaps you should introduce a scheme that was more like the Insurers Bureau, for example.
Indeed, yes.
Yeah.
Did the judge actually, it's difficult to see because the judge declared that the defendant had acted unlawfully by not reading it down, but the judge didn't actually say that it was written down.
Yes, correct.
So how does that work?
How does that work?
What should be read down to?
He must have implicitly found
Yes.
it was read down.
Until that point has been made, that is how I have interpreted it. Is that it's an implicit finding that it must be read down as follows. But the reason why it's put in this way, the defendant acted unlawfully, is, I suspect, but we don't know, a foothold to the restitutionary claims. So, in terms of the discrete point on section 6, I am obviously not here with a full position from the government on that point. So can I formally recall that unless I trouble the court on that, I'm not pursuing it in the way set out for the reasons that have been identified. But other than that, everything else is as recorded in our written submissions and skeleton argument, and including the points by reference to limitation. So unless I can assist the court, those are our submissions.
Thank you very much indeed, Mr. Carr. Yes, Mr. Carr.
Please, your lordship, my lady. The plan of attack is this, that I propose to address the court on the reasons why we say the judge was right for the reasons he gave, so far as he went, and also cover our appeal, which is that he didn't go far enough, and deal with my learned friend's 8 grounds as quickly as I may in the time available. My learned friend, Mr. Tankle, will follow me briefly, I hope, on the question of the case law relating to manifestly without reasonable foundation.
Right.
Some of the points that have been made on that. Although I will have something to say about its practical application to this case.
Yes.
I prefer to do that do it that way around. Of the 8 grounds, as my learned friend has made clear, only one of them really attacks what one might call the merits of the challenge. The rest are either procedural or assert non-justiciability or address the remedy.
And am I right, Mr. Kent, that below you went in reverse order, i.e. it was the technical points which is not doing justice to them, and then
Yes, I think that's
then
right.
the substantive merits, but now we have a change of.
Yes, that's right.
Yes.
And the point about ground 1 is that the sole argument put forward, and one sees that from the grounds themselves in the core bundle, it is that, and this is at page 12, tab 2, page 12, under ground 1, at each stage, the court failed to apply the manifestly without reasonable foundation test. In other words, that's the sole attack being made. Now, I'm not saying that's not an important attack, but it needs to be.
Is that right, Mr. Kent?
Yes,
Heard in its assessment of the alleged interference, and at each stage failed to apply the
Well,
NWRA.
I read that as being the first part as leading into the second part, but in fact, if one looks at my learned friend's skeleton argument, this is the way in which it is put. The point I make is simply this: if one looks at the underlying factual material, there has been no challenge to what we put before the court as to the way in which the law has developed and the way in which, therefore, there are burdens, as we put it, being put upon insurers that weren't there and could not have been contemplated back in 1997.
Yeah.
We accept contributory negligence is in a different category, and interestingly, the learned judge said, well, he could see a rational connection in that case, and that's an important distinction, which I'll come to in a moment. But the underlying facts and the way the jurisprudence, the tort law and the statutory interventions have worked really are not challenged. And my learned friend, in a lengthy skeleton argument, puts forward 8 alleged errors under ground 1. And we say that when you look at those, the attack is always predicated upon what we say is a mischaracterization of both the way the case was being put by the claimants and the understanding of that case by the judge. This is a very careful, reserved judgment provided after long deliberation by the judge. And for that reason, we didn't put in a very detailed respondent skeleton argument, because we do say that a careful reading of the judgment answers every single point my learned friend has put. He makes various criticisms of the way the judge approached it. And can I just give 2 small examples to illustrate why it is not a fair criticism of the judgment, that he didn't misunderstand what was being said. For example, taking the first judgment, it was complained that the judge at paragraph 9 said, which is at page
150.
150.
Yeah.
Referred to it's the last sentence. However, they've also had the consequence of increasing the amount the defendant considers she is entitled under the 1997 Act to recoup. The implication was that the judge thought she was exercising some sort of discretion or power. That is an unfair criticism of the judge for this reason. We put before the court, it's not in the bundle there, my learned friend this morning said that a copy will be supplied. We put before the court a copy of the technical guidance that the Secretary of State issues about the operation of the Act and the NHS schemes. And to demonstrate that the Secretary of State was considered, in other words, was interpreting the legislation in, as it were, a conventional common law literal way, not, as we say, should be done under Section 3. So that's why the learned judge used that expression. Another complaint was that at paragraph 85, and this is paragraph 88 of my friend's skeleton argument, if we could just turn to the skeleton. Yeah. In the skeleton argument of paragraph 88, it is said that in paragraph 85, the court's conclusion was that the insurer's rights were always infringed when an assured incurred a liability to repay benefits. In her application for PTA, the SSWP pointed out that this could not possibly be correct, as for the policies that were created subsequent to the Act, the insurers knew that they would be liable to pay and agreed to do so before the liability arose. And then it said, well, in the face of that, the insurers stated that they had only ever intended for the challenge to apply to policies before the Act was passed. This particular error, they refer to it, has become moot. It was no error by the judge for 2 reasons. Firstly, we had always focused on the retrospective effect. That is at the heart of the statement of facts and grounds, for example, there isn't time to take the court to it, but we had always focused on the retrospective.
You focused on the
Yes.
on the pre-97
Particularly because the jurisprudence says that special justification is required back in Finland and so on. And what the judge was doing in paragraph 85 of his judgment, he was simply describing the mechanism, which is the effect of section 22.
Well, this is dealing with the point about that we've just been discussing with Mr. Brown as to whether or not
It's a one-off.
the interference is a one-off interference in 1997 when the Act comes into force.
Yes.
Whether, as a consequence of section 22(1), it's an interference every time
Yes.
there's a compensation payment, because it's at that stage that the
Yes.
the deeming provision is inserted in the policy, and that's what's actually what the section says.
Yes, it's what it says, and it applies as much to post-1997 Act
I mean,
policies.
it may be said, well, there's an interference both in 1997
Yes.
and in 2019, but
Indeed there is, because the Parliament doesn't know if insurers are going to get their act together and amend their policies in time for the 1st of October 1997. In fact, I'm told they never did. Employers' liability policies still use the same wording, liability for bodily injury or disease, and so they still don't cover on the face of it. But we've no objection to that. But if that's being used to suggest that the learned judge was taking his eye off the ball, that's very unfair to the judge. It was an extremely careful analysis of what was going on. And what we say about the way in which my learned friend has approached ground 1, which feeds through, as my lady said, right through to ground 8 and the reading down, is that there's a mischaracterization of the judge's approach to legitimate aim. And once you get that, once one approaches it from the wrong direction, as we say that my learned friend is doing, then no doubt a lot of his points appear to have some superficial validity. He repeated yesterday morning, made repeated references to what Parliament decided and what it intended to do. Said Parliament could have changed the legislation at any point, and if we didn't like it, we could have made a complaint to Parliament. Parliament can do what it wishes. He said it's quite wrong to impose this scheme, as he called it, on a sovereign Parliament. He managed to say all that without once referring to the Human Rights Act. He did refer to the Convention in passing. And of course, it's the Human Rights Act which makes all the difference, also the will of Parliament. Can I just, right at the outset, take the court to Lord Nichols in the Guyden case, because although this is concerned with reading down, it does explain the width of what is being done in these cases. And Guyden is at tab 55, and someone will shout out the page number if it's... Yes.
Sorry, authorities bundle tab.
Tab 55, it's page 2252.
One, isn't it? Tab 5.
55.
I just had as well.
He did say tab 5 rather than 55, don't worry. And it is
Thank
in
you.
bundle 5.
Tab 55, bundle 5.
Oh, I'm sorry, yes.
Hang on a moment.
It's
Which
not-
tab are we looking at?
Tab 55, I think it's in your Lordship's bundle
And that's
3.
SC.
That's SC.
So neither 5 nor 55 is right. You can try again.
Guidance is early on.
You're on.
I'm sorry, yes. Yes, no, of course it is, yes.
2.
Sorry, I've got the wrong reference there.
It's tab 24.
Thank you. Yes. That'll be the first of many wrong references, no doubt. Apologise. Yes, it was paragraph. It's page 755.
That doesn't help. We've got 3 bundles. Which bundle?
Tab bundle 2. Tab 55.
Thank you.
24.
There was another complication, is that they were so fat, these bundles, I split mine into 4. It's page 755. But it's Lord Nichols of Birkenhead at paragraph 30, referring to the...
This was on the reading list.
Yes, it was, but it is important.
Sorry.
Page 755, it's para 30. And Lord Nichols says, referring to section 3, from this it follows the interpretive obligation decreed by section 3 is of an unusual and far-reaching character. Section 3 may require a court to depart from the unambiguous meaning of the legislation would otherwise bear. And dropping down to missing a sentence, section 3 may require the court to depart from this legislative intention, that is, depart from the intention of Parliament which enacted the legislation. And in the middle of paragraph 31, but once it is accepted that section 3 may require legislation to bear a meaning which departs from the unambiguous meaning the legislation would otherwise bear, it becomes impossible to suppose Parliament intended that the operation of section 3 should depend critically upon the particular form of words adopted. I'm not suggesting my own friend is arguing anything to the contrary, but it's worth bearing in mind when he repeatedly says, well, look at the wording of the legislation, that's the intention of Parliament.
Well, the intention of Parliament in 97. Here, Lord Nichols is looking at the intention of Parliament in in enacting a remedy where there is an infringement, but that doesn't really help us with whether there's an infringement.
No, all I'm saying is that it's common ground applying ordinary canons of interpretation, English common law canons of interpretation, what the legislation means. And that's why we can't attack, we didn't seek to do it by way of a review, as there's a scheme of a review under the Act, because the Secretary of State, we know what the Secretary of State would say, she's issued technical guidance. So we can move on, we say, from the intention of Parliament as being somehow a stumbling block, and that my learned friend is using it to identify the legitimate aim, and it becomes a self-fulfilling argument, because he gets to the point of saying the legislation does have these consequences, they're more acute since Fairchild and so on, but that's what the legislation says. That is therefore the legitimate aim, and that's your starting point. We say that's not what the Strasbourg jurisprudence is all about when it talks about legitimate aim. It's talking about mischief, as the English common law would put it. And we can actually pick that up from what Lord Nichols himself again says in Wilson. And Wilson is, someone's going to remind me where the
Sorry, just going back on that last submission, you say that Mr. Brown is using the intention of Parliament to get to legitimate aim. You need to make that good for my benefit at least. I thought he was saying that the legitimate aim is not to be found necessarily by reference to the stated intention of Parliament in the statute, but by reference to the evidence of Mr.
Well, he
by
did-
reference to the evidence.
He does say that, but he also in places says this is what the Act does, and so that's the aim, and he complains that the judge, as it were, set that aside.
What he said was that you look at the wording of the statute to work out what the intention of Parliament was, which is no more than orthodox constitutional
Exactly.
right.
And
But not necessarily the same as legitimate aim.
no, I think that's a better way of putting it. What we can work out what the intention of Parliament is, as your Lordship says, according to conventional canons of construction and the objective assessment of the wording. But that isn't going to be necessarily the legitimate aim, because the intention of Parliament, in one sense, of course it's right to say that in one sense Parliament intended all these consequences that we complain about.
But it is a circular argument, isn't it? Because if they are entirely overlapping, then you never get to
Yes.
a position where you can complain about it.
Exactly. No legislation could ever be attacked under the Human Rights Act, because it's always
You
saying...
can't
what
ever
it says.
say, well, it's gone further than
Yes.
Well,
legitimate aim, because you're looking at the intention of Parliament.
no legislation could normally be attacked on legitimate aim, because almost always it's fair balance and proportionality.
Yes,
But you're attacking legitimate aim.
Yes, I'm responding to my own friend on this.
Although did the judge find there wasn't a legitimate aim?
Well, he identified what he said was the legitimate aim. We say what he's doing is identifying the mischief, is a better way of putting it.
Well, what the judge says is that the legitimate aim was the three matters that you complained about in 1, 2 and 3.
Well, no, I think what he started off with, what's this legislation trying to get at? And it was correcting...
Well, he's trying to correct
To make tort for fees liable, not the state.
Yes, exactly.
So that was his.
And then correcting the anomaly,
Yes.
correcting the
anomalies in the 1989 Act.
small.
So he was saying that's what... So you have... my learned friend is absolutely right. You do need to go back to the 1989 Act and even before to see how the process from starting off at common law that the defendant had the right to have a credit against for benefits, moving to the 48 Act where the credit was only half for 5 years, moving to 1989 where he still had the credit but then had to hand over the advantage to the state. Moving to 1997, which is the same, save that he hands over whatever the benefits are regardless of the size of the credit. So those are the layers of change. Just looking at the matter at a technical level as to how the acts operate. And what we say is that when you're looking, when the courts are trying to consider what the legitimate aim is, they're really considering the aim. The word legitimate, perhaps, in a democracy like ours, hardly ever creates any problems, because this isn't Henry VIII. It isn't sort of legislation which has an aim which couldn't possibly be legitimate. It has an aim. So what the judge was simply doing was saying, well, what was this all about and what is the aim? And he's not, therefore, bound by the wording of the Act, because, as Your Lordship says, that's self-fulfilling. Nor, and I'll come to it, is he bound by observations of Mr. Towers, which are produced for the purpose of this litigation, and don't find any contemporaneous, I say contemporaneous, any previous manifestation of a statement of executive policy, or parliamentary policy, for that matter. And Lord Nichols, in Wilson,
And that's where?
you told me just now, 21. It's at 21.
Bundle 2 again, is it?
I think this is bundle 1, probably. Oh,
No, it's not.
I'm sorry. At page 624 of the bundle, and this is at paragraph 63 of Lord Nichols.
Paragraph 63.
62, 63. Page 626. 62, oh yes, it's 626. When he said, when a court makes this value judgment, this is dealing with proportionality. The facts will often speak for themselves, but sometimes the court may need additional background information tending to show, for instance, the likely practical impact of the statutory measure and why the course adopted by the legislature is or is not appropriate. Moreover, as when interpreting a statute, so when identifying the policy objective of a statutory provision or assessing the proportionality of the statutory provision, the court may need enlightenment as to the nature and extent of the social problem, the mischief at which the legislation is aimed. So I'm simply citing that to demonstrate that legitimate aim is a synonym for mischief.
Not always.
Well, my Lord, subject to the, as I've said.
I mean, if you want to raise revenue, that's not a mischief.
Well,
Legislation, tax statutes interfere with people's property rights every single day of the week to raise
Some
money, but that's not a mischief.
well,
Corrective legislation may be remedying a mischief, but other sorts of legislation, to describe it as a mischief, is a bit of a...
The mistake you're making here is treating what Lord Nichols says as if it's a statute, and he even puts mischief in inverted commas.
yes, he does. I'm not. It's not so much using the word mischief. It's simply indicating that what Lord Nichols is focusing on is the broad thrust. What underlies, generally speaking, the legislation. Not every little nut and bolt of the detail of it. You come to that when you come to rational connection and no less intrusive than the fair balance.
It's enlightenment on the nature and extent of the social problem, which is what he actually says. Well, that's perhaps a more helpful phrase to summarise what one's looking for.
Yes,
And here, as I understood what Mr. Brown was saying, is he was saying, well, you don't just look at the 1997 Act in isolation. You have to look at it in the context. I think you accepted yourself a moment ago that it's a successor statute too. Yes. So the social problem that's being dealt with is one that goes back to
exactly.
to beverage, for example.
I'll come to that, but that's absolutely right, my Lord. The only point I'm trying to make is that there's a danger of over-analysis and criticism of the judge, who is simply trying to find what it is that that in a broad sense underlay this change that happened in 1997, on top of the schemes and the purpose behind the schemes that were introduced in 1989.
Why is it no more, no less than the imposition on tortfeasors and their insurers of liability for welfare benefits, rather than imposing those liabilities on the victims on the one hand by deduction, if you like, or on taxpayers generally.
Well, my lord, it is but it
And why
is.
isn't that the social problem that's being
Well,
addressed?
whether one calls that a social problem, it may be a problem. It's undoubtedly a problem identified for the first time by the National Audit Office.
Well, the social problem is that industrial disease causes the individuals who suffer from it to need assistance from the state, if one kind or another, and who has to pay for it?
Yes, it's exactly. It's the tortfeasor pays is the shorthand. Our point is, and it's the very narrow point, that the purpose and the social problem that was being identified, the mischief as we would call it, is that the tortfeasor was keeping the credit at the expense of the state for damage which he had caused. That's our only point. I'll come to it. But
So matching, you say?
Sorry.
Matching.
Well, my learned friend has put into our mouths this matching scheme. We don't say that. We talk about a correspondence. And we say that in our skeleton argument below, and it's quoted by the judge. And as my learned friend conceded, you see the correspondence in the Act when you look at Schedule 2, and you see the heads of claim, loss of earnings, mobility, and so on, and the types of benefit that go against it. So it's perfectly clear that there is an intention to have a correspondence. Mr. Bainbridge, no doubt, was receiving his state pension. That wasn't. We weren't repaying that because there's no correspondence between that and the injury.
Doesn't the Act itself make clear that the liability in relation to the benefits arises even if the relevant head of loss is not one which is claimed? That's why we're here. I mean, that's what the Act imposes on.
That's the conventional interpretation.
So I mean, that's
Yes.
that is a demonstration of absence of correspondence. Yes, there is some correspondence. You're absolutely right.
Well,
in very broad terms.
It's a demonstration of absence that has become more obvious and acute since the developments in the Common Law and the Compensation Act. But it's not inherent in the Act because the Act is talking about someone who to any extent is liable for the disease. Leave aside insurers, just looking at it from the point of view of tortfeasors, who are liable for the disease to any extent. And that obviously gives rise to a claim for damages, or alleged to be liable. And therefore you're focusing on the disease that has been caused by the tortfeasor. And then that leads to the machinery of repayment of relevant benefits, and or recoverable benefits they're called, and deduction of recoverable benefits as appropriate under Section 8 from the...
The correspondence in the schedule is as against the claimant in the original claim. So there is correspondence, and one of the great vices of the earlier legislation was that claimants lost a great deal against general damages and other aspects. So that was limiting it and bringing in the correspondence, but there was no correspondence in Section 622, etc., when there's a limitation to recoverable benefits and the CRU certificate, but not a requirement that it corresponds to the claim that's made against you.
Well, on the literal reading, that is perfectly correct. But when we're looking at the legitimate aim and the purpose of the legislation, we say, partly from the way that legislation is actually worded, but not entirely, but also because of the pre-existing development, what led up to it. What is all about the tortfeasor pays for the damage that he has caused. And so to take the example of Mr. Carr, which we put forward as an extreme example, he's someone who, poor man, was suffering from all sorts of conditions and was in receipt of industrial injuries pension for those injuries. The finding of the judge, the evidence before the court, was that the tiny contribution of 2.3% made cautiously by those who were before the court and who could be traced could not have made any difference to his disability. So he would by definition have been entitled to exactly the same benefit, regardless of this tort. And that's an example, an extreme example of divisibility.
It is an extreme example. I mean, you recognise already that contributory negligence raises particular potential challenges for you. But I mean, certainly so far as the no correspondence point is concerned, it's clear that Parliament intended that even if an tortfeasor was only liable for 25% of the damage, the full extent of liability to contribute will be triggered.
Oh yes, there's no
So
doubt.
a clear intention for there to be no correspondence where contributory negligence was an issue, which it very often will be, and is in these types of cases.
Yes, if it goes below, if it takes you below, the loss of earnings then goes below.
So what's your answer to that?
Well,
In terms of the intention of Parliament objectively
Or
construed?
legitimate aim of Parliament.
well, it's a legitimate aim. I repeat, if one just looks at the scheme, yes, your ladyship is absolutely right. Then it catches.
But that is
Carr.
Mr. Brown's point, whether right or wrong, and that's obviously what we've got to evaluate. But what he says is, look at what Parliament said. That's the conventional way to discern its intention. Its intention was not to give you correspondence because they knew that contributory negligence was never going to get called. The judge erred in saying that this was correspondence and then assessing everything from that basis.
Well, that's not
that's really what
Yes.
we'd like you to answer.
We say that's not what the judge did at all.
Not what the judge did.
I mean, I'll come to that in a minute. May I say something about the way in which Section 3 works? Because my Lord, the Chancellor said it would be odd if there's a differential approach to the tortfeasor compared with his insurer. That is a consequence which repeatedly occurs where Section 3 is used to protect a particular class or category of person. It's quite a good example. Connolly and the DPP is a case where the claimant in that case, the defendant in the magistrate's court was charged with sending offensive and indecent material through the post, contrary to the Malicious Communications Act. And what the end result was, although she lost her appeal by way of case stated, or Justice Dyson, as he then was, explained that there's nothing wrong with the language, it's unambiguous, but that there needs to be a qualification put on this so as to preserve rights of free expression under Article 10. And she was doing so, or she said she was doing so in pursuant of her religious beliefs. So you would have two people sending identical material through the post, one of whom commits an offence and one of whom doesn't. That's a good example. It does work in that differential way. And Lord Thomas in the Welsh Bill case drew a distinction between tortfeasors and insurers, unlike the majority. And although that was striking, the whole bill was struck down, one would assume if it was an act of the UK Parliament, that Lord Thomas's approach would be to do exactly what we're asking to be done here, which is to moderate in some way the equivalent of Section 22. There was an identical equivalent of Section 14, rewriting or potentially rewriting insurance policies. That was Lord Thomas's concern. So that would have been a case where the Nhs Charges would have been, the bill would have been sent to the tortfeasor, and he wouldn't have had any recourse against his insurer. And we say, why should he? He hasn't paid a premium for it. He in relation to pre-1997 policies, we don't represent, in these proceedings, don't represent tortfeasors, we represent insurers. So if one, and my learned friends then criticise the approach to legitimate aim made by the judge in the first judgment at paragraphs 115 to 118. Goes on a bit. And I will come back to some of the detail, but having quoted my learned friend's detailed grounds of resistance in paragraph 115, which refers to costs that are attributable to tortious wrongdoing, and we invite the court to note that. Then refers to our acceptance that the objectives of recovering costs attributable to tortious wrongdoing and increasing public resources generally are legitimate aims. This is paragraph 116. However, they argue the scheme established in 1997 as it now applies, and so on, goes well beyond those objectives. Then 117, the defendant seeks to meet this point by stating the scheme's objectives more widely. She suggests the particular mischief, and so that's her word, which the 1997 legislation aimed to address, included the reimbursement of the state for the costs of benefits attributable to injury caused by employers who are no longer traceable, or whose insurers are no longer traceable. So the answer given to our point is purely the missing tortfeasor, the missing insurer, the gaps. And then in 118, the judge says, I do not accept that submission. He's not accepting the submission about, this is all about the plugging the gaps where there are no traceable employers or insurers. Whereas my own friend rather suggested that the judge was not accepting what was said in paragraph 115, which is the formulation of the legitimate aim. And that's why this judgment has to be read very carefully, because the judge was fully alive to these distinctions. And he goes on over the page in paragraph 118 to explain why it wasn't part of the aim or the particular mischief which was referred to. He says it was not, in my view, consciously directed either to any significant degree or even at all to the recovery from employers or their insurers in respect of injuries caused by others, such as non-traceable employers / insurers. Rather, the legislative focus was to deal with problems arising from the small claims limit and the unfairness of deducting from general damages the cost of state benefits relating to other heads of claim. Nor would I accept that the 1997 Act was designed with a view to increasing public resources as an end in itself, without regard to the fault of the compensator insurer from whom contributions were to be demanded. Now, my lord and my lady, this part of the judgment is not to be criticised by reference to the judge somehow trying to get into the subjective minds of the legislator. We see that because in earlier paragraphs he makes reference to the pre-enactment material, the Select Committee report and so on. But what the point to be made here is that that there is nothing apart from assertion, pure assertion, only made in response to these proceedings, that to show that this was all about some sort of revenue-raising effort. So the judge was entitled to take that view, and to take the view, again, by way of a broad assessment, that the aim, let's leave aside the word legitimate, the aim of the legislation, building upon the earlier legislation, was still to get from the wrongdoer the benefits that are attributable to losses caused by the wrongdoer, but to avoid the erosion of general damages for the victims, and to deal with the anomaly of the small claims limit. And that he was entitled to do on the material before him. Lords, it's a bit rich for the defendant before you to complain about the judge looking at this material when it was exhibited by Mr. Towers and was put forward, therefore, as material relevant to this an understanding of what the aim of the legislation was. We didn't argue it in that way. The challenge was simply put forward on this basis. Read the Act, apply the conventional canons of construction, and you will see that it has these rather alarming consequences given the developments, Holtby, Fairchild, Compensation Act.
But it always had the consequence that you would be liable for the whole when there was contributory negligence.
Yes, that's a different, I agree.
It always had the consequence that you would be liable for the benefits that couldn't be offset against income if there was no loss of earnings claim. And one understands, obviously, in long-tail claims, a lot of the claimants have had a full working life and develop it after they've retired. Mm. So those were consequences from day one, minute one, and yet the judge in this part of the analysis appears to link it with common law damages and whether it could be, whereas the Act, rightly or wrongly, and you'd still say it was wrong, always had that consequence.
Well, one problem is that the Secretary of State by order can add benefits to the Schedule 2, and the problem is that, for example, universal credit has now been added. So we're in the position of being at the mercy of the Secretary of State who can go on adding.
Let's just focus on IIDB,
Yes.
which in one form or another has been there for a long, long time.
Yes.
And the point that my lords just put to you was there from the moment this statute, whatever it was then called and whatever was then in Schedule 2, and we haven't got the original statute, I'm not asking for it.
Yes.
But the fact of the matter is, a liability on insurers to pay in circumstances where their insured was the tortfeasor,
Yes.
and was therefore liable or alleged to be liable to any extent,
Yes.
which is what the statute says, then you were, what was imposed by the statute on the insurers was liability in respect of all of the benefits listed, even if there was no head of loss of earnings as such claimed, because so many of these victims were, as my lord says, were people who were at the end, either at the end of their working lives or had retired.
Well,
So to that extent, to the extent the statute, that's what the statute says, that's what the statute was intended to, at least partly intended to achieve, and that must therefore be part of the legitimate aim of the statute, mustn't it?
well, that brings on back to whether every nut and bolt of the details.
Well, that's not a nut and bolt, that's a fundamental.
Well,
And that in a sense is at the heart of the complaint that you make. That we've been found liable for all these benefits in circumstances where our insureds weren't actually liable for that head of loss,
well, my lord, bear in mind that
because it wasn't claimed.
yes, but under the 1989 scheme, so before the 97 Act comes in, there's the right of deduction. That is actually, probably inadvertently, too generous to tortfeasors. It doesn't matter because the state then gets the money. The reason I say that is that under Hodgson and Trapp, you could.
The state didn't. There were thousands of settlements where claimants walked away with £2,500 because their claim for £40,000 was topped up by a CRU certificate, and that's the only time they get money.
Yes.
You then get off scot-free as the insurers for that, and the claimant gets a fraction of the true value of the claim.
Well, Lord, I stand corrected. That's absolutely right, and that was the anomaly that the small claims limit. If one leaves that aside, I'm looking at the bigger claims. At the common law, it was a like-for-like deduction, Hodgson and Trapp. So if there was no loss of earnings, you couldn't deduct benefits because there was no match correspondence, I would put it. Under the 1989 Act, there wasn't that necessary link. It's just a right of deduction, but then you hand it over to the state, but there's no additional or excess liability. And whether things have changed is an interesting question. Under the current arrangements, someone who has the misfortune to suffer from mesothelioma, for example, is treated automatically and immediately as 100% disabled, so they get the top level of IIDB. They also, they and other asbestos injury people are entitled to IIDB they're treated as at least 20% disabled. In other words, so the asbestosis people get IIDB without having to go and have a medical examination. If they're a bad case, they can get even higher. So you get, now my point is simply this, that of course is a consequence of the mechanics of the Act, that there isn't any necessary correspondence. But it's not what was the driving force behind, or the purpose, or the mischief of the legislation.
And that is the critical point. How can you say that when Parliament provided for that scheme? One assumes that Parliament intended what it said in the legislation. Now, that might infringe rights, true, and it might then be read down, but one takes Parliament, and at this stage there was no chance of it being read down because it was in 97. So Parliament must have intended a scheme which was, as you say, unfair to you from the start.
And if all Parliament had been intended to do was get rid of the 2,500 escape route, if I can put it that way, It could have said so, couldn't it? It could have got rid of that, and that would have been it. But Parliament, on any view, went much further than that.
Well, it was the ring
And
fence.
imposed liabilities on insurers, even where their insureds were not going to be liable for the particular head of loss because, for example, the victim didn't have a claim for loss of earnings.
Well, it imposed liability on the insurers or the compensator to ring fence the general damages, recognising that the benefits may therefore not have anything to bite into by way of deduction. That was what we say was the purpose. And while what we say is wrong about my learned friend's approach, is, and I'm repeating myself, is to say that you look at the legitimate aim and say, well, it's what Parliament ordained by the wording of the Act, and therefore we've got to attack rational connection, no less intrusive and fair balance, by reference to that. Well, that would defeat many, if not most of these types of challenges, whether Mrs. Connolly and the Malicious Communications Act or any other act which on its reading has a wider effect, but has at its core a purpose, a legislative purpose.
Well, I'm not sure that's right. I mean, look at Gate, where it attacked, one gender or a state over another state. That was the natural reading of it. That was a legitimate aim. And then it failed along the ways, and then was read down.
Well,
but no one said when assessing the legitimate aim that it was other than what Parliament had said in its literal wording.
well, I rely upon what Nichols said, which is looking at the objective, and coupled with which is it's the mischief, isn't it? And so, which may be an inaccurate word, but that is an expression that is used when you're interpreting, let's say, of an ambiguous provision in a piece of legislation. You look at the mischief without being hidebound by the wording of the legislation. You say, well, stand back, what was it all about? And therefore, how do we interpret this ambiguous provision? And that's all that Lord Nichols was saying. And once one gets rid of this idea that it was anything to do with untraced tortfeasors or insurers, then it's a very, very different picture. On that topic,
The missing insurer point came to the fore looking at the then defendant's skeleton argument, came to the fore in the context of defending retrospectivity or
Yes.
addressing the question of why it had to be retrospective. Is that fair?
well, I think that is right, and I want to make one reference with trepidation to Hansard, and I do it because in my submission this is within the exception identified by Lord Nichols in
Right.
as quoted in the Guiding Authority.
It's all right, Mr. Kent. We
Which
promise
is-
not to bite your head off.
And it is this question of the reason for retrospectivity.
Is that in the supplementary bundle?
It's a supplementary bundle, and it's at reference page 352.
No.
Well, yes, 352
Yes, it is
in
352.
Hansard.
This is the second page. It's the third page of an excerpt from Hansard. Debate on second reading, and the judge has quoted some of this, but I just wanted to refer to one part. This is the minister in the House of Lords, and this is page 352. The middle, sort of third paragraph in the end. My noble friend Lord Chancellor does want to see that. Asked about the provisions in clause 2 and the retrospective nature of that clause. He asked me to reconsider the matter. Lord Chancellor said he'd been briefed by the ABI. I explained in opening we sought to catch cases in existence as well as new cases at the time of change. If we did not do that, people with similar injuries and similar compensation could walk away from the claims with quite different levels of benefit because because of the workings of the two provisions. For that reason, I suggest that we should take the unusual step of making the changes retrospective so that they will catch existing cases going through the pipeline as well as new cases. Therefore, while I understand my own friends' concern, I hope to expect is perhaps the only way in which to prevent serious unfairness occurring in the years after October 1987. I think 97, that must be. I don't know why he said 1987. It must be the commencement.
Yeah.
And it's cases going through the pipeline, and rightly or wrongly, that seemed to be the only justification that we can see, objectively speaking, put at the time, or at any time since then, until we get Mr. Towers' witness statement, of why it was retrospective in relation to insurers. In cases going through the pipeline, he was clearly contemplating cases which hadn't yet come on for trial and were being pursued.
Contemplating, if he thought about it, I suppose, a broader category of case, such as cases where people had suffered an industrial injury which hadn't yet manifested, industrial disease which hadn't yet manifested itself.
My Lord, I'm making a much narrower
That's
point.
how you define
Yes, I accept that it is retrospective. But
Yeah.
all I'm saying is that because the jurisprudence requires, once the interference is acknowledged as it is, under A1P1 first limb, requires justification by the state and special justification where it's retrospective. That's the only reference we find, the only thing which we can see on behalf of the state, which is proffered as justification for it. And until you get to Mr. Towers.
I've gone blank. What extra does Mr. Towers say now to justify retrospectivity?
Well, we ought to look at his witness statement, because this is also in the
Yes.
supplementary one.
92.
Yeah.
And what he says, I think, starts at paragraph 19. Paragraph 12, I think. Yes, paragraph 11, paragraph 12 at page 11 of tab 2. Scheme as an instrument of social policy, he says, seeks to assist with the efficient settlement of personal injury claims, which historically could be complicated and result in hardship. And we just put a question mark in the margin, not quite sure how that follows at all, but that's what he says. Doesn't assist in settlement at all. If anything, we say, as it now operates, it can have the opposite effect, because where a number of putative defendants are in receipt of letters of claim, who wants to be the first to make the move and say, I'll settle your claim and seek contribution from the others, because they're then liable for the whole. In essence, the social policy consensus is that tortfeasors, generally insurers, should be responsible for contributing to welfare payments paid by the state to victims, and where there are shortfalls, the insurance industry should make a contribution. Well, that's, as a generality, perfectly fair and true. The social policy partially addresses the situation whereby employers or insurers cannot be traced, and social costs are therefore left to the state as the safety net of last resort. Now, that's the first time that appears. That's never been stated. We've had no evidence that anyone, the executive, has ever considered that and reconsidered it in the light of changing circumstances, let alone at the time of the 1997 Act. Employers' liability insurance has been compulsory, he says, since 1972. They benefit from the social policy and so on. So he makes points about an interest being advanced, which is the effectively clawing back benefits, some of which could have been clawed back from missing employers, missing insurers. But so what's wrong with clawing it back from those who happen to find themselves in the frame and are paying a compensation payment? And then he says the scheme could have been funded through general taxation. He goes on to, further on, he then talks about, in 19 and 20, he explains helpfully that the efforts have been made by the department and by the insurance industry to establish a system of tracing missing policies. The Employers' Liability Code of Practice, the Employers' Liability Tracing Office, And then he goes on to refer to the diffuse mesothelioma payment scheme and the levy on current EL insurers. And the problem is that he's now gone off at a complete tangent because there are schemes. They're of a completely different nature. We can see that the very first one is actually by Chancellor, I think.
He may have gone off on a tangent, but the fundamental point is he's a senior policy manager with responsibility for the policy relating to the 1997 Act, duty of candour, and he makes statements earlier statements as to the rationale for the underlying social policy. Now, what basis is there to go behind this?
Well, I'm going to come to it.
Just because it was not mentioned in debate in 1996 doesn't mean that it isn't relevant to social policy in February 2020 or
I accept
2019.
A defendant, a government department.
That's the problem with looking at Hansard, isn't it? Because you can't second guess what may or may not have been the thinking of those who actually voted for this. A lot of the people who voted for it may have voted for it for exactly the reason he's identified.
No, but on the other hand, it almost proved negative. I mean, as I say, we didn't deploy this material. We just say, here's the Act, here's the developments in the common law and how it's operating, and it needs to be justified. The attempt then to justify is based upon Mr. Towers. Now, the lady says, what's wrong with that? And we entirely accept that a court having to see whether there is justification is not limited to things that were said at the time.
But if you were trying to justify the retrospective aspects of this legislation, one of the obvious ways in which you would do it is to say that it provides the safety net in circumstances where some insurers will have disappeared, some insurers will have gone into liquidation. We all know the fate of the Iron Trades Mutual, which from recollection was actually around about the time this Act was passed, when they got into difficulty. I think they stopped writing business sometime in the late 1990s. And then we had Chester Street Holdings for a while, and then that went in, I think that went belly up in about 2001.
Well, the point I'm making is that you can't have special justification if you've already got schemes in place. And there are schemes before and after this legislation. The first we happen to see in the bundle is a scheme under the Workmen's Compensation Act section, which is in volume 1 at tab 2.
So moving on now to a discrete submission. The submission is that there cannot be special justification justifying retrospectivity on this matter if there are separate schemes in place in relation to other matters.
Well, I'd say that the court is entitled not to simply accept at face value an assertion made in the course of the proceedings.
Well, there could be other ways of doing it.
Well, there are other, but the point is there are other ways of doing it. Perhaps Section 47 of the Workmen's Compensation Act provided for a scheme that to be set up for a general compensation fund for those suffering from silicosis, later extended to asbestosis, to be funded by the employers and insurers. The mutual trade insurance group was to be set up. As your lordships know, the Policyholders Protection Act then provided a complete code in relation to liability insurance from 1975. Then it transmutes into the Financial Services Compensation Scheme, and in relation to employers' liability, the Financial Services Compensation Scheme, entirely funded by the insurance industry, then pays out 100% in relation to missing insurers where there was compulsory insurance, and 90% in relation to non-compulsory insurance, so pre-1972 policies where the insurer is insolvent. That's funded by the insurance industry. And the FSCS themselves have to hand over to the state under the 1997 Act, not 90% for an old policy, but 100% of the crew benefits. That's how it works, because they're they're a compensator, compensating on the basis of a liability to any extent, on the basis of the underlying tortfeasor. The Mesothelioma Act 2014 is then a scheme which comes in takes it further and deals with cases where there was never insurance. So you have, this is a scheme for where there are employers, whether before or after compulsory insurance, who cannot be traced. And you can't find insurance, so the policyholder, the FSCS aren't in the frame, there's no insurance policy that's missing. And
Well, no insurance in the sense that nobody can trace.
Well, or maybe no
there was
insurance.
any, and if so, who it was.
Yes, well, both. It could be untraceable, or it could be.
Yeah.
But I've identified what efforts have been made. So you have now, and the Mesothelioma Act scheme is a pure common law damages assessment basis. So the victim gets his full damages, and it's funded entirely by a levy on the insurance industry. And what is more, the insurance industry under the 1997 Act have to repay back the crew benefits on a 100% basis, sort of to add insult to injury, as it were. So it is simply, it's no good Mr. Towers, he does mention the Mesothelioma Act, it's no good Mr. Towers simply asserting that this retrospectivity was all about the missing insurer or the missing tortfeasor. The missing insurer had already been covered by the 1975 Policyholders Protection Act. And the missing employer was later covered by the Mesothelioma Act 2014, so 5 years before these proceedings were started. And that is why it is not, and the learned judge did examine the merits of this argument, that is the legitimate aim, for his first judgment. In paragraph 121, he rejected 120, 121. He rejected the analogy with the MIB scheme, which again is a scheme based upon a levy on insurers. And of course, one might have added the Road Traffic Act liability where there is an insurer, but they would have had a right to avoid or not to pay for breach of policy conditions. And so that the MIB scheme is across the whole sector in relation to compulsory insurance, motor insurance. And then he mentions the diffuse mesothelioma payment scheme. And he points out it doesn't impose an individual burden. It's across the sector as a whole. And that is why the judge was perfectly entitled to, when he was looking at legitimate aim, to say it really that's not what this was about.
Well, I'm not sure that is what he's saying with respect. I think what he's doing is he's rejecting the argument. He's rejecting effectively the justification argument, isn't he? Because that's at 120. He says the defendant submits the sharing of risk across the insurance industry by the 1997 legislation is an ordinary and unobjectionable scheme.
Yes.
And then the comparison is drawn with the other schemes, and the judge then rejects at 122 the argument that somehow the 1997 scheme can be justified in that way because these other ways of doing it are much fairer.
Well, justification.
He's not rejecting the underlying argument as to what the legitimate aim is. What he's rejecting, as I read it, is the attempt to justify.
Well, of course, justification feeds right through.
That's the aim, but it's not legitimate.
Yeah. Well, he's not saying it's not legitimate. He's simply saying, and this is why he says in paragraph 118, I do not accept that submission. He's simply saying, if you stand back, the reason for this legislation has got nothing to do with missing insurers. It's got everything to do with the need to ring fence general damages and the small claims anomaly. That's all he's saying, and we say with respect that that's absolutely right. He of course in this section he refers back to his analysis earlier, I think. Yes.
Well, I think we need to move on, Mr.
Yes.
Kent, but at the beginning of 120, what the judge is saying is if, in other words, if I accepted the argument for the Secretary of State, if obtaining reimbursement for the cost of state benefits attributable to the tortious action of third parties had been part of the aims, then it would
Yes, it would
argue
be.
it being a legitimate aim, but that would depend upon the means used to achieve it.
Yeah.
Then he goes on to deal with what the Secretary of State was submitting was effectively why it was justified or legitimate.
Yes.
And that's what he's rejecting in this part of the judgment.
Well, Lord, yes, but he's saying it's not the aim. So he is saying that, and we say
Well, I
correct.
agree with you. But, I mean, the question for us is whether he is right or wrong.
Yes, but we submit he is right, and it is. I take my lady's point about the duty of candour, and this is the Secretary of State's witness, and we don't obviously say anything about Mr. Towers, as it were, making it up as he goes along. You can understand why, as it were, ex post facto, one thinks that might have been, or might indeed be an aim. But when we come, as I've said, ground one is entirely we say entirely based upon the failure to apply the manifestly without reasonable foundation test. And so you ask the question, what's it got to bite on? Because normally when you're applying that test, you have some statement of objectives in a white paper, or you have some preliminary material, or in this context, you might have a discussion as to whether the act should be amended, and then a decision not to, in the light of Fairchild and so on. And so you've got something for the court to say, well, I better look at that and see if those are reasons which are manifestly without reasonable foundation. But here we have a complete vacuum, really. We just have the Act, which has this, that operates in a particular way.
I'm just wondering whether the key sentence here isn't at the end, and I take on board my Lord the Chancellor's point that we need to move on, but the last sentence of paragraph 118. So he's rejected the missing insurer point. He says its focus was on small claims and general damages. But then he says, nor would I accept the 1997 Act was designed with a view to increasing public resources as an end in itself, without regard to, do we read that as the degree of fault?
Yeah.
To the degree of fault. What's the basis?
Well, we would
for
say that without regard, elliptically perhaps, but it should be the
Well, it only arises at all if there's some fault.
Exactly, so it's
It's
got to be the degree of fault.
it's,
and
well, it's without regard to the injury caused by the fault, as it
The
were.
extent of
Well,
fault.
Where does
are
he-
you talking about injury in common law terms or injury as paid out by the state? Because he develops MESO, he then becomes entitled to this benefit. I mean, it depends, if you go back to 115, costs that are attributable to the tortious wrongdoing. The tortious wrongdoing is established because otherwise you're not paying. Costs, the mistake is to read costs as limited to the costs of damages that would be awarded by a
Well,
court.
Lord, it then becomes entirely self-serving, because it means that the Secretary of State will say, well, I can now add a benefit of, I'm going to award people who've got a claim for damages £1 million of state benefit.
Well,
because
if
we'd
the
like to
Secretary of
compensate.
State did that by regulation, no doubt you challenge the regulation.
Well, that's an extreme example.
But we're looking at the
In
Act
real
as it
world,
works.
that doesn't happen.
No, it
I
doesn't.
mean, these benefits are, you know, frankly, pretty exiguous in many cases, aren't they? I mean, they are not £1 million. Look at Mr. Bainbridge. It's
No, but-
19,000 or whatever
Yeah,
it is, and you know, the poor man got another, how much it was, another 22,000 before he died. So we're not talking about huge.
No, but
Some
Lord,
decision by the Secretary of State to, as it were, land insurers with some enormous new benefit that they've suddenly dreamt up.
well, I'm not suggesting that would happen, not least because it would be cutting off your nose to spite your face. It would just go
That's
around in
another
circles.
point.
But
But I think, I mean, my lady's right that in a sense is the critical. I mean, the critical issue for us is really whether what the judge says in that last sentence is right or
Yes.
wrong.
And so my question to you is, what is the basis for that?
Well, it's
In
that
the words of the
rejection.
statute.
Yeah, what is the basis for that sentence?
it is the material that he looked at in section D when he was reviewing the genesis of the 1997 legislation, as he puts it, in the main problems which it sought to address. And so he is saying, if you go right back, you have Sir William Beveridge saying it's essential that benefits are in the hands of injured people straight away, whether or not they have a claim. It's first aid. But says Sir William Beveridge in that rather, it may seem rather paternalistic way, but there shouldn't be double recovery, so they shouldn't keep the money if there is a claim. At that point, no reference to the state getting its money back. And then things move on. The 48 Act comes in and there's a compromise. It's half and half for 5 years. Again, no recovery. Lord Pearson comments in 1977. Again, no reference to recovery of the state. And in fact, Lord Pearson is quoted in the judgment, I think at paragraph 23, says, well, tort law isn't about punishment, it's about compensation for losses. And for that reason, he's in a section dealing with offsetting benefits, specifically considering state benefits. And so the tortfeasor should only be liable for the net amount. Again, no reference to repayment. Until the National Audit Office, no doubt with a view to looking after the national finances, says, well, wait a minute, why isn't the state getting some of this back?
So it was revenue raising because the National
Yes.
Audit Office intervened.
Exactly.
Before the 1989 Act.
But I accept that, and so that led to the 1989 Act, which, as I've said, was deduction matched. The repayment matched the amount deducted. My learned friends sought to argue before Mr. Justice Henshaw, no appeal from it, that somehow the 1989 Act did potentially involve an excess payment, if that was the case. So if someone was receiving more IIDB than their loss of earnings, there would be an excess payment. The judge rightly rejected that. That was not the scheme of the 1989 Act as reenacted in 1992. And so working your way through those developments, what you have is a clear policy objective enunciated, first of all, by the National Audit Office, that benefits which are attributable to tortious wrongdoing should be recouped by the state. And I think it's worth just quoting, it's referred to, in fact, I think it's referred to in my learned friend's, most conveniently, my learned friend's skeleton argument.
Which one?
Which is...
Below or here?
Sorry, but here. And it saves a lot of time because he conveniently set out it's page, tab 8, page 72. So he starts off with the Beveridge report in 1942, and I've already made the point that Beveridge says, well, the needs of the insured person must be met straight away.
So paragraph?
20.
Thank you very much.
And then in 21, Beveridge says, but he shouldn't have his same need met twice over. And then I missed out the Monckton, Sir Walter Monckton, who again didn't say anything about recovery, the state recovering their outlay. And then that leads nevertheless to the 1948 Act and the 5-year and the 50% point. It hasn't been stated, but I think elsewhere it's stated one reason for 50% is that, of course, employers also pay national insurance contributions, as do employees. So there's some justification for that. And then the Pearson report, I've referred to that. He took, as it's put, a narrow view of it, and it's quoted in paragraph 23 of the judgment. I think I've said that it's not a question of punishment. National Audit Office and then the Committee of Public Accounts is quoted. I think this is a quote from them.
Yes.
It must be. We believe that the two long accepted principles that negligent parties should not have any of their liabilities met through the social security system, that accident victims should not be compensated twice, should now be applied. And so the focus is on the liabilities of the tortfeasor. Now, one starts with the proposition that a tortfeasor is liable to the injured person, not to anyone else who may suffer losses, whether it's a business partner who finds his business loses profits, or a wife who has to go out to work, or whatever may happen as a result of an injury. It's trite law that is not, that person has no claim for damages. And it's even more straightforward in relation to the state. So there's no question of any common law liability to the state, merely because there is a but-for causation sequence between the injury and the receipt of benefits.
What the Committee for Public Accounts actually said but he said that those two long accepted principles should now be applied.
Yeah.
It then went on to say, additionally, the financial benefit to social security funds and the taxpayer from a recovery scheme would be very substantial. And that's the context in which a compensation scheme that's was originally in the 89 statute, then the 97 statute came about. And it's got nothing to do with any common law assessment, or when I say common law, any assessment of the liability of a tortfeasor by a court or agreement by settlement by agreement or whatever. It's all to do with. It's all triggered by there being any liability at all. And that's why it says to where somebody is liable to any extent.
But my lord, the words should not have their liabilities met. It's the liabilities to the injured person.
Yeah, but it depends how you read additionally, and again, this isn't the statute. So additionally, a scheme is going to be very, give us lots of money. And then in 1989, they started and they realised they were losing out a lot of money because of the settlements that claimants and defendants were doing to avoid some of the rigours of the scheme. And they changed it again. And the founding principle is that you're only going to make a payment if you've caused this person to become economically and inactive and ill, tortiously, and of course you're going to have to pay all the benefits that are then listed as recoverable benefits. Now, people can argue about whether that's a good or bad scheme, but that seems to have been the legitimate aim behind it in the sense of the policy aim.
Well, my lord, but it was always focused upon the liability of the insurer being relieved by the state.
Well, so that's where it started. You're quite right, but it's not where it ended up.
Well,
and it's the question we'll have to focus on is whether the legitimate aim finished and ended where it started.
Well, Lord, we say it is always and always has remained the tortfeasor pays and shouldn't have his liabilities subsidised by the state. And so in the example given of you have caused someone to lose earnings, fair enough. But what if you haven't? As in a divisible injury case, where the award that the claimant gets would only be for, say, 10% of his loss of earnings against you. Why is the state able to do better than the victim? That's the point. The state is, we say, effectively piggybacking on.
Well, it depends how you define that. That's the whole point. Because if you look at the thing as a whole, it isn't a case of why is the state able to do better than the victim, because the victim gets the benefit. In the example of IIDB, for example, Mr. Bainbridge, he got the benefit. The issue is whether or not it's right that the insurance industry should have to reimburse the state and therefore the taxpayer for the benefit in circumstances where they're insured, for whom they provide compulsory insurance, was the tortfeasor that caused Mr. Bainbridge to have the disease in the first place.
Well, I'll come to that. Probably did not, says Lady Hale.
Well, that's a different issue, Mr.
But well, that is why
we can't deal with that. That's a different issue.
Well, it's an issue we will come to. But I do say that if you're looking at aim/mischief in a broad sense, it was all about the tortfeasor not having its liabilities relieved by the state without reimbursing the state. And so when we come, if you dispose, as we say is correctly disposed of, as any aim that can be, which is the starting point, any legitimate aim being somehow to plug gaps where there are missing employers or missing insurers, when that's already plugged fully by other means, then our case is a simple one. If the justification for the scheme is the wrongdoer should reimburse for the liability, then why are we reimbursing for things for which we are not liable? There are two aspects to this. With contributory negligence, we accept you've got a defined injury, and the benefits go in relation to that injury. Our liability is reduced by the Contributory Negligence Act. it's worth stating that that is only, we're only liable because of the Contributory Negligence Act, Law Reform Contributory Negligence Act 1945, which removed the common law defence.
Yeah. Well, it didn't. The common law worked. Sometimes you'd end up with 100%, and sometimes you'd end up with 0%.
Yes.
It was just a bit of a lottery, depending on where you worked the last intervening act was.
There have been a series of statutory developments. Goes right back to the Employers' Liability Act 1880, removing the doctrine of common employment.
Yeah.
And we're told by, I think Lord Mance in one of these cases, that led to the creation of the Employers' Liability Market, and then the Workmen's Compensation Acts. And you then have the ability that Law Reform Miscellaneous Provisions Act, I think, allows you to sue one tortfeasor. You don't have to sue them all. You then have the 1945 Contributory Negligence Act. Going much further forward in time, you have the Compensation Act, Section 3. These are all victim-centred pieces of legislation. And what we complain about is that the state is standing by without, as it were, getting more and more coming in from the compensators and in particular insurers who issued old policies based upon developments.
Well, I understand that as the general complaint, but if you are looking at the overall matching cost benefit, the state has a 5-year limit. Could have decided not to. The state allows tortious damages to be assessed on the basis of net loss rather than gross loss, with liability on the victim to pay to the state. The costs of NHS treatment for those with industrial diseases are particularly high and not recoverable. So that it is, you're quite right to point out, it's a bit harsh when you look at it one side, then you look at the other side, and Parliament's made a balance.
Well,
because that's the real issue we need to confront.
Yes,
when we finally get to.
I suppose that's right. I do need to take the court to AXA, the judgments in AXA and in.
Well, I think we've probably exhausted.
Yes.
Legitimate aim.
But it is very important because it is the foundation for Merlin and Friends, then approach to the other aspects.
We understand your submission.
And so if one then moves on to the, well, let's look at the AXA case, because in my submission there are important references in that.
You'll deal at some stage with rational connection and power.
Yeah, I was going to come back to that.
Yeah, no, that's fine. So AXA.
Because this is, there are some important references in my submission. AXA is at 23, is it? 33, tab 33, which I think is volume
3.
A333.
Thank you. Now, I think I can take the court is aware of the background and the Scottish legislation reversing a relatively recent decision of the House of Lords for Scotland in relation to the treatment of plural facts. This legislation didn't expressly refer to insurers at all, and there was no need for it to, because this was simply deeming something to be bodily injury. And of course, the insurance covered bodily injury or disease, so it followed the Act. And so the question was whether that was an unjustified infringement. That's at Lord Hope.
So this was the plural plaques.
Yeah, exactly.
And in England and Wales, it's still not actionable.
Never been.
That's my understanding.
Never been reversed. And then we have the reasoning, which focuses, and I don't need to take the court to the detail as to why things are really rather complicated in that case, because of the declaratory theory of the common law is that plural plaques were never actionable, but in practical reality, of course, things were very different, because cases have been settled over the years on the basis that they were actionable. And that was a crucial point, and that's the court looking at the practicality, this time from the point of view of victims, And bear in mind, this is a victim-centric piece of legislation. And so they don't let that get in the way of their analysis. And Lord Hope at paragraph 37. There are two special features in this case which seem to me to show the balance that is struck cannot be said to be disproportionate. First is the claims which the Act makes possible will only succeed if it's shown the exposure to asbestos was caused by the employer's negligence. There's that. And then 38, the second special feature is that insurers were engaged, with the business in which insurers are engaged, in pursuance of which they wrote the policies that would give rise to the obligation to indemnify is a commercial venture which is inextricably associated with risk. And he refers to the risk being the definition of bodily injury or disease, medical
And
risk.
importantly, 39, the nature, number and value of claims. Always
Yes.
liable to develop in ways that were
Exactly.
unpredictable.
And that is, Lord Mance has something to say about that. That's one thing for an insurer who's issued a policy which is on a causation basis and therefore may come back to haunt him years later. That there may be unexpected spikes of claims, as in fact occurred. But that was the risk. Now, no insurer before the 1997 Act was writing a policy, as far as I know, to cover the liability to reimburse the state, because that wasn't a liability that existed either at common law or by way of statute, except in the rare examples, the Road Traffic Act 1930, which was the earliest one, where you could get some treatment charges for voluntary hospitals. Then it became the NHS when that came into being. So in fact, it goes back to 1930, and that will be covered by motor policies from that date. But before the 1997 Act, there was no basis for anyone to contemplate that within an insuring clause that talks about damages for bodily injury or disease, there might be a liability to the state. No more than they contemplated there might be a liability to the victim's employer, who finds that he incurs costs in employing someone to replace the injured person.
So why wasn't the claim brought in 2000?
Well, I'll come to that in a moment. But we're entitled. Our short point is that Section 3 is there to be applied of the Human Rights Act.
No, I'm not saying your statute barred as a result.
Oh, right.
But if you're saying no one could understand it, it was a terrible shock, and then the remedy appears in 2000, one might have expected it to have been used earlier.
Yes. I suppose the answer is that it takes time for the prodding of the creature to cause it to bite, as it were, or to growl. I mean, it's got worse.
Perhaps you didn't have excellent legal advice until later.
So Lord, that's and then paragraph 40 of Lord Hope. It might have been different if the law on the actionability of plural pacts had been settled by judicial decision when the policies were written. The effect of the Act would have been to reverse the settled law after the date when the insurers committed themselves by their contract to indemnify. So, although it's obiter, obviously, Lord Hope is contemplating a different result if by settled decision, before these policies of insurance were written, the plural pacts were held to be not actionable.
That's paragraph 40, is it? Yeah.
That's paragraph 40. And that's notwithstanding the fact that this is victim-friendly legislation by the Scottish Parliament.
So we're looking at area of risk if you look at the last sentence, are we?
Yes.
The interference can
exactly.
therefore be seen to be within the area of risk with which they engaged.
Yes. And so until Rothwell, in the I think it was the Court of Appeal and then the House of Lords, these claims were being pursued. And then Lord Mance has something to say about retrospectivity. I know I'm moving on to other aspects, but paragraph 91.
And what did Lord Mance say in this case?
Yeah, I think they were unanimous that it was an acceptable interference with existing, even though it was retrospective. And he says the key to this issue is paragraph 91. is not, in my view, that insurance is a contract against risk. There are always limits to the contingencies upon which insurers speculate, provided by the terms and conditions of the policy. Further, insurers are normally entitled to expect that the liabilities which their insured employers incur arising out of and in the course of their employment, and which they insured under the specimen copy policy to which I've referred, will be liabilities capable of existing in law at the time of the occurrence during the relevant employment from which such liabilities arise. I should say, if anyone wants to look at it, there are specimen policies at the back of the supplementary bundle, but they're in standard form of liability for bodily injury or disease of the employee arising in the course of employment. And then he refers to in 92 to the Rothwell decision decades after the relevant employment insurance. But it represents a decision as to what the common law is, and in legal theory always was. This is no mere incantation. And so he says that's a problem for the Scottish government defending this. But then he goes on in 93. There are, however, circumstances in which legislation with retrospective effect in respect to past conduct may be justified. Gives various examples. And 95, he says, the key to the present appeal is that when the relevant policies were issued and the relevant employment occurred, there was no certainty whatever how the law might treat claims for plural plaques if and when they ever emerged. Wave of asbestos-related claims which hit the United States of America in the 1970s, United Kingdom in the 1980s, itself largely unforeseen. Remained uncertain how the common law would treat such a phenomenon. Entirely possible to regard plural plaques as potential basis as a claim for injury. He refers to Lord Hope in Rothwell and Lord Hoffman. It was possible to regard the bodily change. And so one can see how carefully the Supreme Court analysed the problem, and that it was far from a clear-cut decision. And it was only because there hadn't been a clear common position of what the law was when these policies were written that enabled the court to say that retrospectivity was justified. Whereas here, no one can argue the law ever allowed or ever required a tortfeasor to repay state benefits. The law allowed the tortfeasor to have credit under Hodgson and Trapp, modified that by statute, modified it again in 1989, requiring a handover of the credit.
But I'm not sure that your point about, well, nobody could have contemplated this really holds good, does it? Because if you look at the examples that Lord Mance gives of retrospective legislation, one of them is Section 3 of the Compensation Act 2006. And I rather suspect that if you were an employer's liability insurer, one of your client in its previous incarnation, writing an employer's liability policy in 1974, let us say for the sake of argument, the last thing on earth you'd have contemplated is the liability position that's arrived at by Section 3 of the Compensation Act 2006, that even if you'd only, as it were, cause, and using cause in a very broad sense, 2.3% of the
Oh no, because that's CARDA. That's
disease. You end up with 100% of the liability.
Yes, no, my lord, the Compensation Act is limited to mesothelioma. That's an indivisible.
Mesothelioma, yes.
But that's an indivisible disease. So the insurers would always have said to themselves, well, if we have a claim that is satisfied, that is a good one, that the insured has caused mesothelioma, we pay 100%.
When did the law decide what was divisible and indivisible?
Well, Barker and Chorus.
No, when there was a lot of arguments about what was divisible and indivisible.
Oh, I'm sorry. Yes, there are. One has to be careful here because the truly divisible is a matter of medicine, which is asbestosis. Is a good example.
Absolutely,
and that's Holtby.
And that was the first time that people had started to really understand those aspects of it before. I mean, if you look, frankly, before, general practice had been to treat all these things as divisible.
Yes. Well, if anything, the other way around. The Boddington and Castings, as Lord Justice Stuart Smith said in Holtby, no one took the point. It was an all or nothing argument. We're not liable merely because we made a material contribution, but no one took the point about divisibility. And Holtby took, the point was taken in Holtby, and although it had featured in Thompson and Smith ship repairers, Mr. Justice Mustall as it then was back in the 1970s for noise-induced hearing loss.
1984.
Oh.
But it goes a bit to your point about liability for 32% or 2.3%. When you were writing the policies before 97, actually people hadn't really thought about divisible or indivisible. If you were liable for causing any part of it, there was a risk you were going to be liable for the whole lot.
Well, exactly.
It's only we've now got a better understanding of the medical etiology of these diseases.
So in that sense, the question I was asked was in relation to Section 3 of the Compensation Act.
Yeah.
Why is that retrospective? Well, in that sense, the insurers would have been, or the underwriters would have been expecting to be liable for 100% of all these injuries. They might have had an argument about divisible.
But one of your complaints to the judge in this case is, this is very unfair, we're being held for 100% of a divisible injury.
Yeah, well,
So you can't find the other one.
well,
But no, because that's a very important point, because that's effectively the argument as I understand it, that Mr. Brown argues against you in relation to proportionality. This was all taking the rough with the smooth.
well, Lord, there are two quite separate questions. One is this question of the area of risk that insurer is underwriting. We accept in relation to Section 3 of the Compensation Act, which is a victim-friendly piece of legislation. No insurer could say, well, I didn't think I was insuring for 100% of a Fairchild liability. But they would simply say, well, you knew you were insuring for bodily injury. He's got mesothelioma. Well, that's within the area of risk of the policy that you underwrote. That's one thing. But when one comes to payments to the state, which then we say piggyback on these developments which are victim-friendly, and it's Barker and Chorus then explains that the common law position is if you have to rely on the Fairchild rule, which means you are being made liable when, as Lady Hale said in Sienkiewicz, you probably did not cause the disease. She actually said that, I think we quoted that in our skeleton. But Barker and Chorus, fairness requires that you're only liable for your time on risk share. That is the position which is arrived at the common law. It's corrected by Section 3 for the benefit of victims. But again, the state, as it were, ride on the coattails of the victims at that point. Even though, well, I've made my point. So those are different points. When I'm looking at AXA to identify the scope of the risk point, and pointing out that it was still fairly finely balanced, even though it was a claim by victims of tortious exposure to asbestos. Around the same time, there was the trigger litigation, which of course clarified the position as between, which is the next, I don't think I need to take the court to it, it's the next authority in the bundle, but that is again a claimant-friendly approach because although it's as between the employer and the insurer, where you've got insolvent employers, it's the victim who is likely to be the one who loses out if the insurance doesn't respond. And then we move on later to the Equitas case where a different view is taken at the level of insurance and reinsurance, because you have no victim in the frame at that point. By definition, you've got the victim his claim has been satisfied. And we say that we're like insurance, reinsurance is like insurer and the state in relation to the state benefits. And then the Welsh Bill case, because we say this is focusing much more on something close to this case, which is tab 38. I've just been taken to this, so you know the background to it. Lord Mance, speaking for the majority, starts off his section dealing with A1P1 at paragraph 35, page 1480. And although my learned friend says that's overture, which we submit is not right, because there were simply two reasons why the bill fell foul of, on one hand, the Government of Wales Act, and on the other hand, well, it's both Government of Wales actually, because the Act had a provision saying your legislation must comply with the Convention. So it fell foul of the Government of Wales Act, both on the basis of the powers devolved to the Welsh Assembly, as it then was, and on the basis that it infringed the Convention. But
I mean, if you were going to say it's not overture, how do you deal with the first 4 lines of paragraph 35?
well, it's not the way in which we would submit. It's not the way in which the judge expresses it, strictly speaking, because when a judge says it's not strictly necessary, that is true of any decision where one conclusion is enough to dispose of the case.
Well, that's exactly a description
Of
of
overture.
when one part of it is part of the ratio and the other part is overture.
Well,
I mean, the first part of paragraph 35 is judge speak. For this issue doesn't arise, but it's been fully argued. I'll deal with it, but it's overture.
yes. Well, we would submit that if a court deals fully with 2 arguments, any one of which is enough,
Well,
then
I'm
each can be
afraid
treated as the ratio.
that is a very heterodox
Because
submission.
he could have put the A1P1 first,
Yes.
and then said of the other one, this now doesn't arise for. So, I mean, it may be a misreading on my part, but I'd simply read this as overture. I mean, that may not be an answer to the good points in it from your point of view.
Yeah, just because it's overture, it is Lord
Well,
Mance.
exactly.
The Supreme Court.
I was going to make that point, and my own friend's right to say it's considering a different piece of legislation. So in that sense, it's not binding on this court.
I mean, I'm speaking for myself, I simply don't know the answer. Whether, because it isn't in fact a decision of the Supreme Court, either on appeal from the Court of Appeal or on appeal from the Court of Session, but it is a reference under the Welsh statute. Whether it has some different precedential effect so far as this court is concerned, I just don't know.
Well,
I think I'd be
it's
tempted to say that we shouldn't go down that route.
no, I would, and I certainly, I don't think either side is going to be right. And I mean,
Do you know whether it is binding or not?
no, I don't think anyone knows. I don't think I'd question that myself. I don't think it's very rare. These references are very rare.
Yeah.
Usually they work their way through the hierarchy of courts.
Was AXA was a case that had gone through the Court of Session?
Yes, it went through the court
Yeah.
session.
But this was the Consul General who had a right to refer a matter to the Supreme Court.
He referred it because there was a challenge made to him, and he, as it were, thought, well, I better let the Supreme Court rule on it. Challenge made by the insurance industry. But leave aside its status. Lord Mance then proceeds through 36 paragraphs
Yeah.
to deal with A1P1, and Lord Thomas, and speaking for himself and Lady Hale, proceed again through 35 paragraphs dealing with A1P1. So they haven't skated over it, and it is very fully discussed. And I think the Lordships have got the nature of the legislation was very similar to this, no doubt partly modelled on the 1997.
But what's curious is, so far as one can tell, I mean, I haven't read every single word, including the argument. The 1997 Act is never mentioned once.
No,
Never deployed as an argument that this piece of legislation is modelled on Section 22 of the 1997 Act, which has been in force in
Yes.
England and Wales for however long it was then, 18 years.
I'm dredging my memory because I happened to be present in the court, and I think it may have been mentioned in argument, but only in passing. I think Section 14, as it was clearly modelled exactly, precisely on Section 22 of the 97 Act. But there are a couple of points to make. paragraph 38, the Counsel General sought to rely upon the possibility that there had been a private medical care. It would be part of the claim, which is obviously right, but that cut no ice with Lord Mance. But we're nowhere even near there. There's no equivalent of a claim. Let us say you have someone who has suffered no loss of earnings, but gets this benefit. There's no equivalent of a claim he might have made as part of his claim that he hasn't. And he agrees, paragraph 41, that the compensators and their liabilities, insurers, are both affected and potentially deprived of their possessions, alters existing legal liabilities and imposes on them potentially increased financial burdens arising from events long past and policies made long ago. And at paragraph 43, he says, the position under the present bill is a fortiori that which existed in acts of the bill is clearly directed at both compensators and insurers, but it is also expressly directed at insurers as well as compensators. Moreover, it imposes liabilities on both, not only in conjunction with its existing liabilities, but in addition to them. It does so in the case of compensators by making it irrelevant whether the compensation reflects any actual or admitted liability. It does so in the case of insurers by making them liable in circumstances where the insurance cover, which they granted, would not apply. For all those reasons, both compensators and insurers are, in my opinion, regarded as victims. Then it's of interest to see what was said in paragraph 63 by Lord Mance.
Can I just ask you about the point about policies long ago, etc.?
Yes.
Your policies are very long ago, pre-97, we all understand that. But this Act, the 97 Act, was pretty long ago as well.
Yes.
And the challenge only comes along in the last
Yes.
couple of years. How does that affect what we should take into account as the fair balance, assuming we get that far? You would say there's no rational connection.
We say the court was taking into account of the evidence put before it. There may be, but if nothing is produced beyond what we've seen in Mr. Tower's statement, then there is no reason to say that the Section 3 obligation of reading down, that the infringement continues, and the Section 3 obligation of reading down should be a continuous one.
And although you've perhaps carefully not identified all the claims you're going to bring, under the declaration that you've got, are you going to go back to 2000?
We're probably going to try to go back 6 years.
But
I
say
haven't.
back to sort of 6 years before the
Proceedings were issued. But my lord, I should just say something about it, which has caused some concern in the court. The position was that we set out what we said was the correct way to deal with any claim for damages in our statement of facts and grounds, and that's quoted in paragraph 92 of the judgment. And it's
92.
yeah. We looked at it a little earlier today.
Yeah, but it says you haven't formulated your financial losses.
Yes, but it gives the reason which we cited in our statement of facts and grounds that this was an exception to the general rule enunciated by Lord Justice Singh in the Nazim Fayed case. And we had no response one way or the other from the defendant.
No, I'm not saying they're scot-free on this. What I am saying is that it's caused absolute chaos with the declaration we've got and the arguments that, well, limitation is somehow agreed between the parties to be kicked off to the Chancery Division.
My lord, what we would do, a declaration of something being unlawful is rather like those cases in the European Court of Justice. The franked investment income case is a good example, where the court declares that some action taken by the state is unlawful in European law. So that's the finding. It's unlawful, and then the parties, the claimants, then bring their proceedings. In fact, as it happens in the Chancery Division, the franked investment income claims, and they've been backwards and forwards up to the Supreme Court about 3 times. They bring their proceedings for a private law claim under the Woolwich or the Klein-Wolf-Benson basis, saying, well, it's already been pronounced that it's unlawful by the European Court of Justice. And so then there are issues about limitation, unjust enrichment, and all those other issues that arise in that context. But those are not public law issues. That's why we said, well, they don't need to stay in the administrative court, and the judge agreed. So there's nothing wrong with a declaration of something being unlawful. It doesn't give you an immediate remedy for damages. It simply says that the law has been wrongly applied from these dates. That's how the Act should have been read, from the relevant dates. Whether that gives you a remedy is yet to be determined. And that's why...
But there's then an issue, obviously, if you're looking at whether it's a claim in restitution or however. If it's a claim in restitution, then there's obviously an issue as to how far back you can go.
Yes, exactly. And there are arguments you can go back.
And if it's a claim for damages under the Human Rights Act, there's another argument about how far back you can go, potentially.
Yes, well, that's much shorter.
Yes.
That's a year, I think, isn't it?
Yeah.
But you are the person making the claim. You're saying this was unlawful from 2000. I don't see why we shouldn't have known what basis the claims are, because the whole point of the judicial review allowing claims for damages is that it can all be dealt with, rather than there's a declaration in Europe. If it's a European declaration, you understand why it has to be dealt with later in private law proceedings.
My lord,
But this should all have been dealt with in one go.
well, Section 31(5), I think, of the Senior Courts Act allows you to add a private law claim into judicial review proceedings, but you don't have to. So we could have issued a claim form then or later, and awaited the outcome of the judicial review. And that, of course, happens very often in the administrative court, unlawful detention cases and so on. So
the detention cases include the claim for damages and other remedies.
well, they didn't have, all I'm saying is they don't have to. That you take your chances. Of course, there'll be if you wait too long, you may have limitation problems.
And despite your evolving argument, you say that the first 3 October 2000 dates in the order are right, do you?
Yes, we do, and my learned friend hasn't really developed that, but the fact is no opposition was put to our proposed dates below, so the judge didn't have much to go on, other than what we said.
No, but
I mean, your point you made a moment ago was that despite those dates, as it were, you'd only be going back 6 years, even for a client
Well,
of Benson. I'm not holding you to it.
Thank you.
Okay. But I think just exploring my Lord's point, with which I've got a lot of sympathy, that there's a bit of a mess here.
Well, the problem
Because
is
I can see if leaving limitation to one side, you go back to 2000, then you've got all sorts of issues about, never mind limitation, but to what extent was the position in 2000 that claims that were being paid were actually claims that you anticipated you were going to have to pay anyway.
well, my Lord, I agree, and that is one
This is
reason.
not, the problems that you are complaining about in very broad terms come after Fairchild, don't they?
Yes.
And they get worse, you say, for your clients as time moves on, and then there's an issue about how much worse and when and so forth.
But my Lord, the more complex a claim for restitution or damages is, the more there is a good reason for the administrative court to focus on the question of lawfulness, and not to have extensive disclosure, which would have to be given by the defendant as well because one will probably be looking at samples, a statistical analysis of claims paid. It's the only way to do it, where thousands, hundreds of thousands of claims have been paid. It will be done almost on a statistical basis, which both sides would have to get engaged in. My Lord, so back to paragraph 63, if I can, of Lord Mance in the Welsh Bill. This deals with a point my learned friend made, because he said there wasn't really much justification put forward by the Counsel General. 62, the Counsel General submits that AXA was a stronger case for treating the legislation as incompatible than the present, yet the Supreme Court did not do so. I do not accept the Counsel General's analysis. The Scottish statute in issue in AXA affected all outstanding and future claims, and the present bill on its face also affects all future compensation payments made in respect of outstanding and future claims, but the two differ in important respects. A, the Scottish statute was passed to rectify a perceived injustice directly affecting those suffering from asbestos related diseases and was in this very real sense social remedial legislation. Pausing there, we've had that expression or something similar deployed by my learned friend in relation to this in this context. And effectively he's saying, well, a revenue raising provision is can be treated as social remedial legislation. But we submit that if that phrase has any meaning, it is talking about putting right ills that a sector of the community or individuals are suffering from. In that sense, otherwise virtually all legislation would qualify. And then he goes on, despite the Counsel General's contrary submission, the same cannot, in my opinion, be said of the bill. It has no effect on sufferers from asbestos-related diseases. Its purpose is to transfer the financial burden of costs of their hospitalisation from the Welsh ministers to compensators and their insurers. And then he says the Scottish statute was to restore the legal position as had been understood before. So that's exactly our case, that it is not social remedial legislation as that phrase is used by Lord Mats. It has no effect on sufferers from asbestos-related diseases. Its purpose is to transfer the financial burden of costs, in this case, of benefits from the Welsh ministers to
Sorry, is
compensators.
that right? It has no effect on victims? It does have effect on victims. It ring fences the 2,500.
I'm sorry, lady.
Sorry. The 1997 Act did have a direct effect on victims, didn't it?
Well, it improved their position.
Yes.
Yes, but the point that
It was part of the whole. I mean, it was part of the overall package.
And what the point that Mr. Brown made was that if you look at the four groups of compensators or tortfeasors and their insurers, taxpayers and victims, the 1997 Act is effectively determining where the balance should lie between those various competing interests.
Well, he says that, but the point I'm making is that the analogy here is with the obligation to pay the NHS costs. The victims already get the free NHS treatment, so their position is neutral.
No.
And the victims here already get the benefits. My lady is quite right, of course, that their position is enhanced in that they don't suffer an erosion of their general damages by the 97 Act. But I'm focusing on the Section 6 obligation, which itself is of no interest to victims. The victims couldn't care less whether Section 6 existed or not.
But can you chop up a piece of legislation like that
Well,
for these purposes?
Well, I submit you can. What we're looking at is an obligation to pay the state. It might have been in a completely separate statute, which might have been dealing simply with recovery of state outlay of benefits, just as this was dealing with recovery of state outlay on NHS treatment. So we say there's no distinction of principle. And incidentally, on the first, on the next paragraph 65, there's a reference to section 15, because I think my learned friend was asked about what was going to happen to the money. And it's recorded, just a fourth line in paragraph 65, the section 15 of the bill contains the specific enjoined that the ministers should have regard to the desirability of equivalent sums being made available for research into treatment of or other services relating to asbestos-related diseases. It is not shown that any such sums so expended would add to existing sums already being spent in these areas or resolve any exceptional social or economic problem. Common knowledge that funding the NHS is under increasing strain throughout the United Kingdom, and so even more, and maybe even also in Wales and elsewhere, but that is a different level of general problem to any shown on the authorities to be relevant in the present context. And then in 66, the Counsel General maintains a special justification exists for the retrospectivity involved in the bill, because without it, the bill cannot achieve its legitimate policy aim. That is a circular submission, which, if accepted, would eliminate the important balancing stage of the proportionality exercise. And that's the point that I've already covered, which is that it becomes self-fulfilling if you say, well, that's what the Act does. So that's its aim. And Lord Thomas, as I've said, has many paragraphs, but 35 paragraphs along with Lady Hale, and his conclusion is right at the end, penultimate paragraph 139.
Is that everything you want to submit about?
Yes, I'm sorry, I've gone over mine.
No, I'm just conscious that if there were anything else on it, well.
No, I think it's sufficient if the court could just look at Lord Thomas at 139 at some point.
So, 2 o'clock, it is.
Court rise.